Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your on-time host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And with me today is just you and me, chat. How you doing? What's up? How you been? What it is? Joe ringside. I'm really glad to join y'all tonight. This week has been wild. Frankly, it's been wild. As you guys know, of course, yesterday we had a little bit of a heated stream. I guess one might call it heated. Is that the appropriate term? It was interesting, right? We had the Ty Beard on, the Beardicus Maximus, Primarch Tyrone Beard, Perseus Tyrone Beard, whatever it is. I am so thirsty today. I went for a run, which I have not had time or willpower to do lately because I'm so busy. But I wanted to address a couple things from the last stream in the last day or so. Then we're going to take a dive into the Texas Defamation Mitigation Act. No. The Texas Civil Participation Act, Citizens Participation Act. Oh my goodness. The Anti-SLAPP statute in Texas. We're gonna take a little gander at that guy. And that should be good. What else are we gonna do? Oh, there's so I said this is a Friday night fun stream. And what is more fun than resetting the clock on another journalist elite being a complete pedophile, right? What makes us happier than seeing the cops actually arrest an actual predator? I can't think of much. So there's a guy out there who's a former Ars Technica writer, Ars Technica being owned by Condé Nast. So not only does Condé Nast employ balding, unfunny Armenians, they also apparently employ pedophiles. And we're going to go ahead and we'll read the criminal complaint against him on the stream. So I hope you guys are excited for that. And, you know, trigger warning, when we do, you may go into a murderous rage, right? Because these real predators are so vile. And of course the complaint, which I have not read. I'm with you going into this live, but I did look at the PDF of the document, just a brief scan of it, and I can already tell that they have the text messages, or not text messages, whatever. They use WhatsApp, right? They have the communications between the undercover FBI agent who arranged the sting, and they have the messages from the horrific, disgusting, looks just as you would expect him to, anti-Gamergate journalist, right? So we're gonna read through that. I will ask you to gird your souls and prepare yourselves by your brass knuckles for slaying the demons that Constantine wore, right? With the crosses and the Latin on them or whatever, made out of the finest, purest silver, coated pewter. And then we'll read those. That's going to be later in the show. So you don't have to, because if you haven't been with me for one of the streams where we talk about the realities of pedophilia and especially these online predators, The court documents don't pull punches, and there's something about the very straightforward delivery in black and white text of the most evil stuff you can imagine. It makes it a little bit worse, more soul crushing. Okay, so we're gonna go through that later, but first I'm gonna talk about the stuff from yesterday and today. Oh yeah, guys, I'm like behind. I'm coming up with jokes and I'm forgetting to say them. Everything's wrong. YouTube is not like updating the viewer count or anything. Like, everything's broken on YouTube. Even sharing this stream was hard. And by the way, if you're here and you know, we're on Twitter or whatever, you saw the message and you came here, which is great. Thank you so much, of course, for showing up. Check and make sure. I've been hearing reports that my channel viewers are not getting notifications of live streams. You may be unsubscribed. Your notifications may have been turned off. Make sure that you are, in fact, subscribed. Make sure you like the streams, please. I don't like asking for it, but I mean, it helps so much. It's crazy. So if you could just double check that, because I have gotten notifications from a few people that YouTube is not properly notifying them when the stream starts. And that's very frustrating, of course, because, you know, YouTube sent me a survey today about how they're doing as a platform. And of course, I had all sorts of fun things to say, but I just want to make sure. I never want to like run on and say nobody's getting notified, because I know that sometimes some people just don't get them. I like randomly get notifications for some people and randomly don't for others. I don't know. It's weird. So there you go. What's next? Okay. So yesterday, Mr. Percy Tyrone Beard was on the stream. He was spitting a little bit of fire, right? Because you have to understand, his reputation, his firm's reputation, I think, which matters more to him, was called into question by the drive-by lawyer militia, just trying to suck the last bit of cummies out of Ken White's boring, flaccid penis. To put it politely, so what they do is you'll when you're when you're a lawyer who has Twitter, you'll understand very quickly that there's something called law Twitter or legal Twitter or whatever you want to. I don't know. I don't engage with this crowd typically, but there's a legal Twitter or law Twitter, just like there's a black Twitter and a white Twitter and all this stuff. It's amazing. All of these people like to be, you know, segregationist and get into their own little circle jerks or whatever. Ken White is Popat. He is the patron saint of law Twitter, and getting him to recognize you, to notice you, senpai, is something that all of these boring, thoughtless lawyers on Twitter really aspire to. Ken White is good on some stuff. Absolutely. He seems to be a very interesting and accomplished lawyer. He's a great legal writer. That stuff's fine. But Ken White is of a very overt political perspective, and he, you know, he's not, he doesn't hide it. That's fine too. But these lawyers will take something like one statement out of a Texas Defamation Mitigation Act letter, and they'll act like this one statement is the basis for a defamation claim. It's not. No matter how much you try to educate them, as they are not Texas lawyers, neither am I, of course. Neither am I a Texas lawyer. But no matter how much you try and educate them on Texas law, either from a Texas lawyer or from other people who have researched it, they don't want to listen, because suddenly they're entrenched in a position where they can't back down. They can't back down or have sense talked into them. So let me break down for you in the realest of terms what this argument boils down to, okay? Because I think this is useful. I think this is more useful than than any of the Twitter arguments would be, than any legal definition or statutory citation or case citation will be for a normal human being to recognize this explanation is the best. So, oh, that was a little self-congratulatory, wasn't it? My explanation's about to be better than all the others. So, under the Texas Defamation Mitigation Act, you have to attempt to find all of the statements from up to 90 days before filing suit. Okay? All of them that you can. And the act is very clear. All of the alleged defamatory statements. You have to get all of them. You have to demand a request for correction. Oh man, I'm not going to remember something, or retraction. Okay? Clarification. Goodness. Correction, clarification, or retraction. You have to request this. You have to. This is not an optional letter. All right? The courts are split on this in two ways. Either some courts dismiss if you don't do the letter. They have dismissed cases and said you cannot maintain the action because you have not sent the letter. Period. Dismissed. Or you can maintain the action, but you lose exemplary damages. So you just cut your damages award in half. All right? Your potential damages award. If you don't do the letter. So you have to do the letter. It's a legal requirement. You have to address every potentially defamatory statement. Here's what happens if you don't. Let's say you have 20 defamatory statements that you can identify, and you miss one that the other 20 are like around from the same medium, and you made your reasonable effort, but you missed a very important statement. The defense can then claim this defamatory statement did the damage, and they didn't request a clarification, correction, or retraction. That becomes a way for the defense to defeat the entirety of your It's like, actually, it wasn't all these things. It was this statement. Now they have to make the case for it. They have to make factual assertions that link that statement to the thing. This would be in the damages section. So this would be after they lost, of course. But you have to plan this in advance. It's required by the statute to do so. And missing something could mean losing the case. You know what will never lose the case? Overstating the case. Taking a statement that might not otherwise be defamatory and laying out that it is defamatory and trying to explain why will not lose the case. But missing that statement, if it is defamatory, will. So, that said, just to clarify this, missing the statement, bad. Including a statement that might not be defamatory, not a big deal. Judge says this isn't defamatory, we move on. The statement in question was definitely defamatory. You are a literal criminal with no criminal record at all. There's no criminal record. There's no criminal filings. You are a literal criminal. Defamatory per se, especially in the context of all of it. Now, the rest of the part says that he's a piece of shit, right? And so they argue first that the literal criminal is not, that's defamatory. And then they go the extra step of laying out that a human cannot be feces. That is also defamatory. Okay. If the judge doesn't buy the human can't be feces argument and just says that's an insult, fine. They have still complied with the Texas Defamation Mitigation Act letter requirement to the extent required by the statute. It requires you to take extra time. So when all of these drive-by lawyers come through and say, you don't have to include that. What they're advocating, what they are sincerely advocating is that you should not thoroughly prepare for the case. You should under-prepare on the assumption that a judge and jury will 100% agree with you and that the other side won't see the opportunity in what's being done and use that against you, which is the worst legal advice I can possibly imagine. It is the worst idea to undersell your case. Why would you understate something in a court of law? I don't know. Now, you shouldn't obviously overring everything and make everything pages and pages and pages of pleadings. That's not necessary. But you should definitely cover all statutory requirements to maintain a case. And the suggestion from a drive-by attorney saying you don't have to do that, who admittedly is not read up on Texas law, has not read the case, and is unfamiliar with the factual allegations, for Mr. Doucette to come out and say that is frankly stupid. It's not irresponsible. There's nothing that can happen to him. He's just a guy commenting and spouting on the internet. That's fine. He can do that. But when he tries to sell it as his own authority on it, it's stupid, because now if he's shown to be wrong, then he looks like an idiot. To be fair, he already looks like an idiot. Okay? So, that said, they can criticize the letter. It doesn't matter. This is part of the circle jerkery of law Twitter, right? I found something, one stupid thing in a filing. Ha ha ha, worst attorneys ever. Clearly, they have never read the lawsuit from Maddox. That's fine. But, you know, that's that. And that's okay. That's okay. But these guys coming out and saying that, it could look very bad for them. They made definitive statements about the outcome of the case and the quality of the lawyers. If you call a lawyer a terrible lawyer based on one statement and then they win the case, what are you then? I don't know. But let me be clear. Let me be clear. The case is not won, right? It's not an easy case. Defamation cases are never easy. I hope you've never gotten that impression. Defamation cases are easier now because they write it all down. They publish it in a self-authenticating way. You know the tweets came from Ron Toye, for example. We know the text came from Ron Toye. His defense to him making the statements would have to be that that he didn't make the statements because his information was hacked. That's what he would have to argue. Something along those lines. I swear, I turn off autofocus and then it turns it back on. It makes me want to scream. So they're easier. They're easier now than they were. They're not easy cases. This is certainly not a slam dunk. However, there are multiple reasons to file a lawsuit. Now, I firmly believe they have a winnable case. I can tell you that Ty Beard would not take a case that he did not believe he could win. You know, you don't have to take a case when you run a law firm with lots of clients. It's not like they're a random guy. They're not like me, right? When I was practicing more, having to take pretty much anything that walked in the door as I was starting my law practice. Their law practice has been going for a long time. They have big clients. They don't have to take a case they don't want. So I know that Ty thinks he can win this case. I think they can win the case based on what I've seen. But you never know that you can win a case. So part of the calculation in bringing a case says, how else is this case beneficial? I think, personally, that this case is beneficial beyond winning or losing the case. As I've stated, I hope to achieve something. I believe Vic is innocent. Wholly, within my being, believe it. I've had conversations with Vic. I've had conversations with people who know Vic. I've had conversations with conventions who have had Vic for years. I've had conversations with frankly, with people who don't like Vic. I've had conversations with people who've had bad encounters with Vic. And none of them think these allegations are true. Not any of them. Even the people who don't like him say, you know what? I'm not a big fan of him. And by fan, I mean, like, I'm not his friend. Okay? But this isn't true. My goal is to take the evidence that I have seen, the people that I have talked to, and take what I believe to be true, which is I believe this has been a coordinated witch hunt against Vic. I think that's obvious from the evidence. I think that they don't have any evidence that what he's done is even remotely approaching sexual harassment, much less sexual assault. I don't think he should be banned from cons or from working. I don't think any of that. So my personal goal, and I believe I've been upfront with this from the beginning, is that I want Vic's reputation to win long before the case does. I don't know if it means he gets to stay in the anime community or anything like that. I want Vic to be able to succeed wherever he goes long before the case happens. Now, if some crazy evidence comes out and Vic is actually a predator, then that's what happens. But my God, I can't imagine him undertaking this case knowing things will be made public. I can't imagine him continuing to fight if he had those dark things in the closet. I can't imagine him doing that. Maybe he is. I also can't imagine that we wouldn't have seen it already with how much attention he's gotten, how much fire the other side has been under. There is no way. These people can't keep their mouths shut for more than 48 hours under their own lawyer's advice. But we're supposed to believe that they are sitting on this massive pile of slam dunk smoking gun evidence. I can't wait to see it. Oh, and they'll have to present it on Monday because that's the discovery deadline for Monica and Ron. So, we'll see, won't we? That said, I still think he's got a very good shot at winning this case. One of the better defamation, tortious interference fact patterns you could find. Let's address a couple of those points. Actually, I've got to find this guy's specific Greg Doucette. Now, this is going to be a problem because I have to find 3 tweets from a guy who has tweeted 400 times today and probably still counting. Oh my gosh, I wish I had this. He laid out a 1, 2, 3 of problems with the complaint, and I want to address them very specifically. Let's see. Where are they? Oh my gosh, this guy sucks. Do you know how many tweets 400 tweets in a day is? You know what's really amazing? This guy has admitted over and over to not having read the documents. He's admitted it both overtly and in subtle ways, like saying, well, if they assert an affirmative defense of truth, then the burden will shift. Yeah, they did. They did do that. If you would have read their response, you would know. Oh my God. There are so many. This guy tweets so much. Oh, here you go. Here's how you know someone's on your side, right? And how you know someone's been keeping up with the fact pattern. If Vic were serious about salvaging his career, he'd drop the lawsuit and either wait for things to die down or affirmatively make amends. Instead, his lawyers are Streisanding the hell out of this. Oh, yeah. Yeah, that's the notice what happens every single time, right? Well, if he's just quiet and if he just lets them repeatedly step on his corpse, if he just would shut his problematic mouth and go away, then he'd be just fine, right? Every single time. Here we go. Oh, another thing. This guy says that insults are not defamatory. Insults can absolutely be defamatory. Here, insults are never defamatory, people. Never defamatory, people. There's no comma. Never in any state in the union. That's not true. That's not true. Actually, in my own state, there's a specific case where a cop, I've talked about it before, his name became, I think it might have been a former cop, his name became Mike the Pedo in town because he married a young wife. Sort of like Shane, right? Shane married a significantly younger woman. So did this guy. He got called Mike the Pedo so much that it became a thing, even though it wasn't true. It was just that he was like 40 and married a 19-year-old or something like that. So he's called Mike the Pedo all the time. And then someone else made a blog or an article about him being a pedophile and everybody calls him Mike the Pedo. Oh my goodness, he won that lawsuit. Weirdly enough, calling someone a pedophile subjects them to an extreme amount of public scrutiny, and you can't just do it. Especially, you bald idiot, if you're framing the insult not as an insult but as a fact statement. So when people are calling Vic a pedophile, a sexual predator, a rapist, those things are not framed as insults. Those are framed as factual allegations and assertions about Vic. And they have caused damage. So you can't say they're not defamatory. They absolutely can be defamatory. It'll be a fact question for a jury as to whether or not it's defamatory. But if you would take the time to read the statements, you'd notice they weren't just a passing insult. These are factual assertions intended to defame and reduce his reputation to other people. But you're a defamation expert, right? You should know this. Why aren't you representing it that way? You know, it's interesting. This guy is passing himself off as just a neutral observer, yet giving legal advice to both, apparently, Jesse Pridemore and Mars Girl. Now, notice what's funny. Notice what's funny about Greg. Greg says, listen, I do pro bono defamation cases, and the Thought Patrol comes running as fast as their broke, irrelevant, fat asses can muster, running as hard as they can, harder than they've ever huffed in their entire life, trying to get to the free lawyer. Please, dear God, help us in this case. Never. Oh, can you imagine? Mars Girl probably stood up to reach all the way to North Carolina to hand this idiot her papers, right? They have never gone as fast as that. As, a bald fat man wants to give me free advice. It was amazing. It was amazing. Oh my goodness. You can... Oh, good God. Let's see. I'm still looking. Oh, this is another one. This is a dumb statement. Where did it go? I lost it. This case is going to lose. Period. Whether it loses on an anti-SLAPP motion or loses on summary judgment, the end result will be the same. Their literal only hope is to pray the cost of paying defense attorneys is so high that the defendants settle. No, it's not. This case is going to lose, period. What a ballsy statement. I'll give him that. He not only looks like a scrotum, he might have one. Maybe. But here's the thing. All that has to happen for him to be wrong is defeating the anti-SLAPP, which is prepared for in advance. And we'll talk about it in a minute. And then defeating summary judgment, which we'll also talk about in a minute. I don't know why you would make a definitive statement about the law. I may have said that I think even on Maddox's lawsuit, I think I said something like, I'm pretty sure this is going to get dismissed for failure to state a claim. I'm pretty sure. But still, I couldn't. Oh my goodness. Let's see. Here we go. So where are we? Good God, how much do you tweet? The answer is way too much, obviously. Where are we? Can't tortiously interfere with a contract that's not alleged. Misunderstanding notice pleadings yet again in Texas. You don't have to plead all of the facts. You barely have to plead any. You just have to give sufficient notice. All they had to do is plead tortious interference with existing and prospective contracts. That's it. You don't have to list the specific contract. Where are these? I need to find. I should have found this earlier. I'm terrible. I'm so sorry. But I'm going to find it. He's got a 4-part thing. Where are we? This is back on. This is yesterday. Oh. I have to find it. Maybe I might have taken a shot on my phone. No, why would I have done that? Where is it? Okay. I don't think I'm going to be able to find it. I might have to search specifically. If anybody can find this and send it to me via DMs or something somewhere. Where is it? If anybody can do that, that'd be great. Hold on, I'm checking something. Oh, yeah. About the guy who chimed in. No, that's not thanks, Automata. That's not actually the DM it's not the message I'm looking for. Let me see though if it works. I might be able to find it from this. The guy who chimed in on Ty's post, who laid out a thoughtful sort of thing. That guy, I have invited him on the show. He's not going to be on there tonight. Obviously. But here, I'll just go ahead and start addressing some of this stuff. Let me pull this up. I'll just do this live. Here we go. Do it live! Let's talk about some of these tweets. Now, I read the lawsuit. He read the complaint. He didn't read the answer, apparently, which is all the court will be considering until summary judgment. That's not true. That's not true. Again, this is a fundamental misunderstanding of how Texas pleading works. In Texas, you make a notice pleading. Then, upon any motion, you have to add other things, okay? So, when you make a motion for the TCPA, the defense, or the plaintiff, I guess, because the defense makes the TCPA motion, the plaintiff gets to respond, and they get to use the evidence that they have to make the case. Something like that. My brain's breaking. My brain is breaking. Hold on. Let's see. I'm trying to think how this works. Now my brain is fried, of course. But they get to, actually, I don't know if they even have to provide the factual basis for it. They get to allege their statements, and the court has to take those statements as true and determine if these statements are true, does it create a prima facie case of defamation? So they get to argue that in a motion hearing. So it's not actually all the court will be considering. They'll hear their motion arguments from both sides. The other side, I don't think, gets to put up counter evidence in the motion for dismissal under the TCPA. But it's very possible that the plaintiffs get to. I'm fuzzy on that. I'll have to check. We're going to look at this in just a second. Let me see if I can pull it up. I'll pull it up here. See. Evidence. Let's just go ahead and... Here we go. Let's just go ahead and use the law to prove him incorrect. I guess that's the best way to do things, right? So, can you guys read this? All right, I'm going to do super chats in just a second too. I just want to start getting into this, because otherwise I'll rant on forever. So this is the actions involving the exercise of certain constitutional rights. So if we go to chapter 27, we go to definitions. Civil Practice and Remedies Code 27.01. This is the Texas Defamation or Citizens Participation Act. Hold on, let me see if I can find that specific title, just so we're clear. No, of course not. Thanks, guys. But you'll just have to kind of trust me. That's what this is. Okay, so we can go to definite purpose. Here we go. Purpose of this chapter is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time protect the rights of a person to file meritorious lawsuits for demonstrable injury. Okay? So next, we have a motion to dismiss. If a legal action is based on, relates to, or is in response to a party's exercise of the right of free speech, right to petition, or right of association, that party may file a motion to dismiss the legal action. Yes. A motion to dismiss a legal action under this section must be filed not later than the 60th day after the date of service of the legal action. Court may extend the time to file a motion under this section on a showing of good cause. Remember, Casey said that it was really hard to get an extension. That's not true. It's very easy to get an extension. Showing of good cause being we have agreed to an extension would suffice. Except as provided in 27.006b, on the filing of the motion under this section, all discovery in the legal action is suspended until the court has ruled on the motion to dismiss. Right? So this is that discovery stay that we talked about. Hearing. Hearing. A hearing on a motion under section 27.003 must be set not later than the 60th day after the date of service of the motion unless the docket conditions of the court require a later hearing, upon a showing of good cause or by agreement of the parties. But in no event shall the hearing occur more than 90 days after the service of the motion under section 27.003, except as provided by subsection C. So they have 90 days to rule on this, other than this exemption. So in the event that the court cannot hold a hearing in the time required by subsection A, they may take judicial notice. The court's docket conditions require a hearing at a later date, but in no event shall the hearing occur more than 90 days after the service of the motion, except as provided in C. If the court allows discovery under section 27.006b, the court may extend the hearing date to allow discovery under that subsection, but in no event shall it be more than 120 days after service. So maximum you've got is 4 months. This is a hard limit, y'all. If they fail on this, if they fail to meet these limits, either 90 or 120 days respectively, even if they rule that the defendant wins, the defendant doesn't win. They have to hold this hearing within 90 to 120 days. That's just it. They have to. Okay. So the ruling, we'll do that one next. Zoom in a bit more. Let me, hold on. They've got this sidebar that is required to be there for no reason that matters. Let me hit some of these chats real quick, and then we'll keep going on this. Don't worry. Mither and Emmer says, "Dang it, Nick, you and Ty have me rethinking my research topic to address the split in the Texas courts regarding the TDMA. I may have to talk to my professor. On the plus side, it would give me an interesting specific focus." Chronoflation says, "For people upset about the Ava Netflix original status, that is just a marketing term for all their exclusives. Getting Ava was a passion project for the lead guy, that the lead guy made his first priority after being moved to Japan." Inkpenification says, "Hey Nick, if you're interested, I'm hoping to have a discussion with you on the difficulty of the legal system keeping with the speed of technology. AI is slowly becoming hard to discuss from human thought." I think you mean not discuss, to distinguish between human thought. Yes, I am interested in that, and I reminded you to please remind me in DMs on Twitter or in on whatever. Oh, thank you. Thank you, Automata. Yeah, this is what I was looking for. Thanks, buddy. We'll pull that up in a minute. So here we go. Mithrin Emrys says, "Also, do we now have definitive proof that the super lawyer tag is simply the equivalent of the bench warmer going to the trophy store and paying for a most valuable player trophy to put on their shelf for validation?" I mean, I'm anxious to see a super lawyer who isn't a chump. Chronoflation says, "Let's be happy Netflix got Evangelion. Pick your poison. If you ever want more like this, Netflix's Japan lead is a good guy who really wants to make the fans happy. Let them know that's good when you complain about original status." Okay. Intimidator 0108 says, "Hey Nick, I don't know if you caught Tug's stream earlier today. I did not. But I sent him some screenshots of some very interesting tweets from Jesse Pridemore after talking to Greg. It explains a good part of her recent cockiness. Well, she can be cocky all she wants. She's got more to worry about. She didn't just say someone was a rapist. She said someone raped her. That's gonna be a problem for her. Prove it. Because you're gonna have to assert truth. Chronoflation says, "How dare you, sir? I am Armenian and you can insult us far better than that. I'm disappointed in you, sir. How embarrassing." Well, I wasn't insulting all Armenians, just one. Mr. DJ Fly says, "Have you seen the YouTube channel called Ad Hoc, where he made a YouTube video about the Vic case saying that the case is meritless? You should do a live reaction video of it. I sent you an email about it under urgent. I've seen the channel. It's got 40 views, something like that. I don't know. How much do I want to help this guy? How much do I want? Yeah, that guy looks like he's going after that sweet, sweet cosplayer sympathy side boob. Legendary Super Saiyan E-Rock says, keep me company while I'm driving, Nick. I don't like driving alone. Hashtag no homo. Gladly, buddy. Reek says, evening, Nick. About to hit the gym. Get pumped. Give a portion of this to Vic next time you get a chance to donate. I keep forgetting to get around to it. I can't donate to the GoFundMe. Kieran Fellwinter says, have you watched My Cousin Vinny starring Joe Pesci? A couple times, yeah. If so, how would you judge its accuracy in representing the legal process? It's actually shockingly accurate. They did a very good job. Qualifying the expert witness was great when Marissa Tomei has to talk about has to answer the automobile question from the prosecuting lawyer. Yeah, actually, in my Federal Rules of Evidence class, the judge who was teaching it was very fond of using My Cousin Vinny clips to teach the Federal Rules of Evidence. They're really well done. Thank you for your dedication to following Vic's case and getting people interested in real law. My pleasure. Bowser Jr.'s descendant says, in the words of Omni King Zeno, all of existence, go away. Baron Nathan Dean says, I've asked to get in on his charity drive because he's betting people $100 each that the case won't ever go to trial. Haven't heard back yet. We'll see. We'll see. Here's the thing, though. Vic could win on summary judgment, too. F says, howdy, Nick. But, by the way, one of the assertions, one of the factual assertions is that Ron and Monica have, I think, I don't know if this is in the case, but if it's not in the pleadings, it's going to be asserted, I would assume, is that Ron and Monica have contacted multiple conventions privately, right? So summary judgment is where all of the material facts to a case are agreed upon by the parties. And then once all the facts are done, you don't need a jury or a judge to act as a fact finder. You just need the judge to apply the law to the facts that are agreed upon. Sometimes it's a stipulation. Sometimes facts are clear and convincing beyond the other parties. So if they assert that Ron and Monica contacted other conventions and Ron and Monica say, no, we didn't, now you have a genuine issue of material fact. Whether or not they contacted more than one, we can tell they contacted Kamehacon. Whether or not they contacted other parties will really matter. And that would be a genuine issue of material fact, because if they can link their communications to any other con that dropped Vic, or especially if they can link their communications with one party that then spread to these others, that's going to increase damages. Well, they're going to raise that. They're going to say that didn't happen, right? They're going to have to argue that. If they don't argue that, they're admitting to tortious interference, or at least one of the major elements of tortious interference. So you can bet they're going to have a genuine issue of material fact that will require a court to resolve it. So you're probably going to get past summary judgment unless they admit to everything, because these are material facts. They're gonna, I don't know. Anyway, it's crazy. It's crazy that this guy is so cocksure that this is going to end on summary judgment in the defendant's favor, no less, when he's not aware of what factual assertions exist because it's a notice pleading. So in the notice pleading, you're not going to get notified of every single thing. I've said this. I'm repeating myself. But I've been repeating myself on notice pleading for 30 hours with this moron. Doesn't seem to get it. He doesn't seem to understand. Hey, what's up, Tug? What's up, Tug? Let's see. Yeah, so we'll see. We'll see. F. Thank you for the big donation. F says, howdy, Nick. Remember me? Well, maybe. I've been out of the whole Vic thing for a while, so I'm almost certainly a little ill-informed on what's been going on. Man, it's crazy. But the summary of the Vic thing is that Vic was accused of a bunch of stuff. There are particular statements from some very nasty people who are very close to him, who have ties with the conventions. We can prove that they contacted at least one convention, and subsequent to that contact, the convention decided no longer to work with Vic after they stated some allegations that were misrepresentative at best and outright false at worst. And even in Texas, they were not privileged to make those communications. So they seem to have tortiously interfered with at least Kamea-Con, if not some other cons. We have all sorts of defamatory tweets and statements that link up with Vic losing specific con appearances and losing a bunch of money. This has all been pled out, and the other side has responded with a document that serves only to defame, doesn't really make any valid legal points, and is largely ridiculous. There was a squabble over discovery, and then we're at where we are now, which is sometime in the second half of this month. Depositions will happen for both Vic and Monica Rial and Ron Toye. And then after that, I expect a TCPA motion to be filed by Ron Toye and Monica Rial. We'll see. We'll see. So I hope that summary helps. Dustin Fitzfar says, Twitter has been linked with lowered IQ if used in excess. You block posting links. Otherwise, I would post a scientific study. I had to. Porn spam bots blew out the chat. And I had to. I couldn't even keep up with the chat to try and delete them fast enough. So I had to get rid of them, which is weird because I know so many regular viewers had trouble posting links to the chat. Porn spam bots had no such trouble. Boomer says, stop acting like my namesake. Also, who would win, Rabute Gilliman or Sanguinius? Battle to the death, no interferences. I think Sanguinius, one-on-one. I think Sanguinius wins. Nova Zero says, American rules are the norm on YouTube, that and feelings. But here's an interesting Australian law way to teach the regulation of expression in Australia. I introduce you this abstract. Greg is a literal pedo. Oh no. Roman Franco says, what I find paradoxical, you and Ty on Twitter equal fake lawyers, but this T-douche tweets favorably to Kick Vic and is welcome into the fold, and they latch onto his teat. Why isn't he a fake lawyer too? I don't know. He's a criminal defense attorney who closed his office and started a podcast. Gah! I don't know, right? Like, every one of those things has been levied against me to discredit me as valid. Oh, and he's also a non-Texas lawyer. All of those insults or pejoratives or whatever have been levied directly at me, saying that I am not qualified to comment on this because I'm not a Texas lawyer. I closed my office. I mainly do criminal work. And, oh, by the way, I'm whatchamacallit? Oh, I'm on internet. I'm on the interwebs or whatever. So there you go. There you go. But it's that confirmation bias, right? Well, he has to be right. Ugh. Akiva Cohen, not a Texas lawyer. I don't know much about that guy. That guy accused me of committing a felony. It's very embarrassing to accuse someone of committing a felony when you fail to meet the basic elements of the felony you accuse them of committing. So that's fine. That doesn't really bother me because I know I didn't commit a felony. Or I guess I'll just wait for the FBI to show up and arrest me. All right. Okay, so we're caught up on those. Are there any? All right. Let's get back to this. Okay, back to where we were. This is back to the TCPA. Oh, my brain is so jumbled right now, guys. I'm very tired. Tomorrow I will not be streaming. I wouldn't normally, but I would normally, because since I'll be in Matsuri, I'm going to stream on Sunday night. Okay, I will be streaming Sunday night because I'm going to Matsuri, and I think my streaming conditions at Matsuri might be impaired a little bit. We'll see. We'll see. I'm going to see if I can maybe get a cool live guest or something, but no promises. So I would normally stream tomorrow and Sunday to kind of make up for the absence for the Matsuri convention, but I can't tomorrow. I'll be at a charity event, and I need to wind down and have that day. But Sunday will be the next stream. So it's a little out of the norm. But you know, my apologies. My apologies. But all right. All right, all right. I think you hear the FBI knocking on the vault door. Okay, so this is back. Oh, there I tangented. My joke. Dang it. I went for a run today, and after 2 miles of running, I actually considered crowdfunding a CPAP machine so I could make it home. That was my joke. Oh, but the second joke was, but I'm not a broke North Carolina fatso. I would buy my own CPAP machine. Guys, please don't ever let me reduce myself to asking you to buy something for me. Please, please don't let me do that. I'll ask you to fund a lawsuit I'm not involved in. Oh my God. I overlooked one of the biggest, funniest things about this moron. These people have over and over and over again called me a grifter for crowdfunding crowdfunding a legal offense for other attorneys to take. They have called me a grifter for trying to raise money for someone to hire a different attorney that I don't get a cut of. I don't get a penny of that money. I get no dollars from the GoFundMe. This guy is crowdfunding legal stuff for his own firm and his own clients. But he's not a grifter. I'm a grifter because I am raising money for somebody else entirely to take, and I get zero. This guy takes money into his firm, his own firm, and he's not a grifter. Is it only because he's not successful? I don't know. I don't know what the ruling is on grifting. I'm not sure how all this works out. Will somebody, academics, please respond? I need an explanation on how grifting works. I need to get better at it. And here they are, swinging from his shriveled testicles, just loving their confirmation bias. Yeah, a lawyer incorrectly stating the law over and over, who didn't read the case or the documents, who's unaware of the facts in the case, who also likely hasn't seen the text between Ron Toye and Kamea Khan. He agrees with me. He says there's no case. He has no idea how this works, but I'm gonna hang from these nuts just because he said it. Well, sure, he appears to be a broke, unsuccessful lawyer who can't afford health insurance or a CPAP machine, who claims to do pro bono work, who is not in Texas, who has a podcast, who closed his office, but, oh, and he crowdfunds money for his own law firm. But dang it all if he doesn't agree with me, so I don't know what to do. I'll ignore all of it. Okay? Okay. I don't know how far to take jokes. I think I'm a sociopath. Travis the Bard says, you think they had better things to do and get tired of pointing things out. They need to get laid. Anyone willing to bite that bullet? No. No, please no. Don't do that. Don't do that for them. Ryan Mercado says, an attorney who hasn't read the pleading and document says the defendants would win on summary judgment. Nick, how did T. Doucette graduate from law school and pass the bar exam? I don't know. I know idiots who pass the bar. I went to school with idiots who passed the bar. I'm sure I went to school with people who think I'm an idiot who passed the bar. That's fine. Oh. Okay. This is all getting you guys just warmed up for the pedo stuff later that we have to talk about. I got to get the jokes out now. Sorry. Back to the Texas Civil Participation Act. This is important stuff. Okay. According to T. Greg Doucette, and we're going to look at his three-part. I'm going to take a break before the next section, which is evidence. According to T. Greg Doucette, the court will not consider anything outside of this on a TCPA. He's sure it's going to either win under TCPA or win under anti-SLAPP, or summary judgment. That's where he thinks they win under either TCPA or summary judgment. So we're going to address the TCPA and check out the merits of his claims. We're going to read the plain letter of the law, and then I'm not going to pull up Supreme Court decisions on this, but I might pull up the summaries of them, and we might go through and just kind of take a look at it and address some of his concerns. Let's read this one. This is the ruling. The court must rule on a motion under section 27.003 not later than the 30th day following the date of the hearing on the motion. So again, worst case scenario, you have a 90-day period, 120-day period because a judge orders a limited discovery related to it. And then you have another 30 days. So you get to 5 months potential. Best case scenario, it's much quicker than that. Remember, this judge was able to get a hearing on the discovery issues within 1 week of requesting, if Mr. Casey Eric had been available, which he was shockingly not. Within 1 week of requesting, they had a hearing on the docket. So in this case, they basically have to follow the general rules of Texas civil procedure and I don't know them. I cannot tell you them right now. I'd be lying to you, but it's likely something like you have to give something like 21 days. If you file a motion, there's 21 days that the opposing counsel has to respond, and then you have 10 or 7 days to respond to their response. It might be shorter. It might be 14, 7, and 3, something like that. I don't know the rule. I'm not going to pretend to, but there will be a period of time, and you get your motion request, the response to the motion request, or request for the hearing, and then you go to have your hearing. Okay. You don't have to wait. They don't have to wait 60 days. They don't have to wait 90 days. They can docket it as fast as the court is available, within a reasonable amount of time for the parties to file their, well, actually, since the motion is being made, the defense can file a response to the motion as fast as they can file it. And then that would just leave the one timeline, or the one time frame, which would be the response to the response. And the defense, or the plaintiff, I guess, files the response to the motion along with a hearing request. And then the other person files a response to that. And then the hearing would be set as soon as the court can docket it. Actually, probably anytime. They probably have to just give you 3 days, maybe 7, something like that. Very, very quick. Very, very quick to the motion hearing. Except as provided in subsection C, on a motion of a party under section 27.003, a court shall dismiss a legal action against the moving party if the moving party shows by a preponderance of the evidence that the legal action is based on, relates to, or is in response to the exercise of the right of free speech, right to petition, or the right to association. C, the court may not dismiss a legal action under this section if the party bringing the legal action establishes by clear and specific evidence a prima facie case for each essential element of the claim in question. So, notwithstanding the provisions of subsection C, the court shall dismiss a legal action against the moving party if the moving party establishes by a preponderance of the evidence each essential element of a valid defense of the non-movement's claim. So they'll have to prove, remember this, they won't have to prove the truth of their statements. Yes, they will, because they will have to establish each essential element of a valid defense to the non-movement's claim. So here's what happens. They file their motion, right? Vic will respond and say, here are all the reasons why you should not dismiss this case. Here's our clear and specific evidence. Bam, 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 bam. 400 tweets. Text messages to Kamehacon. Emails. Possibly testimony under oath from other parties. Okay? They may not even have to make the testimony. They may just have to allege that they can get the testimony or verified affidavits from other parties. Like, say, the owners of Kamehacon, for example, might be able to make a statement by affidavit about what happened to them. They do all that. Then the burden shifts to the other party, which I've been saying over and over and over again. They have to then assert truth as the defense, especially at this stage, because the defamatory statements are going to be presumed to be false. They will presume them false because this is read in favor of the non-moving party. The moving party on a TCPA is the defendant. The plaintiff is the non-moving party. The case will be read and the evidence will be read favorable to the non-moving party, as such that if these things are true, then you win. Or then do you establish a prima facie case? So then they can provide, by a preponderance of the evidence, proof every element of their affirmative defenses that they've asserted. They'll have to do that. So they will have to prove the truth of the statement. These people have been saying over and over again that the victims will, or the defendants will not have to prove the truth of their statements. They will bear no burden, that Vic bears all the burden. That's not true. It's in the law that it's not true. I don't know how else to tell them other than taking a sledgehammer, etching this onto the face of it and ramming it into their foreheads so that when they look in the mirror, they read, I'll have to write it backwards, I guess. They read, the defendants will have to bear the burden of proof for all essential elements of their defenses. And an essential element of truth as a defense is the truth of the statement. Have we caught up now, Sir Greg? All right, next. Evidence. In determining whether a legal action should be dismissed under this chapter, the court shall consider the pleadings and supporting and opposing affidavits stating the facts on which the liability or defense is based. So, Greg, let's go back to your tweet, shall we? Remember, you're a defamation expert, right? I read the lawsuit, which is all the court will be considering until summary judgment. What other parts of the claim have actually been pled? None. It's notice pleading. But under the fucking rules, you idiot, you get to support it with an affidavit asserting the facts. You bald, dumb weirdo. You don't know the law. Why in God's name do you keep asserting that you do when you're so routinely deficient? You're wrong on all of these points because you're actually right on basic defamation law. You're fine. You've got it. That's a good little thread that you wrote. Great. You've established the basic steps for defamation in most jurisdictions and federal court. However, you are wrong on the Texas law that you're purporting to know. And it's right in the statute. It's right there for you to see that they get to support it with an affidavit alleging facts which will be presumed correct. Do you understand? Do you get it yet? Why won't you read the rules before you talk? I don't know. You're such a great lawyer. But you won't read the rules, and you won't cite the rules. Why? Could you not crowdfund your Westlaw subscription, you baby? You have to follow the rules of the TCPA to file a TCPA claim, especially if you want to prevail. So if you keep asserting that the plaintiffs only get to go on the pleading, which may actually be true in a non-notice pleading state where you have to allege with particularity the facts being asserted. And I've tried politely to let you know that Texas is a notice pleading state. So merely sufficient notice of the causes of action is enough, not the underlying facts. Those come when the motions require them. So under the TCPA, you dummy, Rule 27.006, both parties will be able to support their pleadings and motions with affidavits stating the facts or defenses for their respective positions. Now, please tell me again how much you know about Texas defamation law. We're waiting. Well, this is interesting. Let's go ahead and stroll down to that next little subsection. On a motion by a party, or on the court's own motion, and on a showing of good cause, the court may allow specified and limited discovery relevant to the motion. Even if you don't have the evidence, you can ask the court for an additional 30 days plus some discovery, like a deposition, like affidavits, like actually demanding document production. Because sometimes the TCPA comes right away and the other party needs the discovery tools to go ahead and pursue their claim. You don't always get to say no to discovery, and you don't always get to run on pleadings. In fact, under a TCPA, you never run on just the pleadings. It's almost like it happens by motion. And it's almost like in that motion, you get to support it. And if you can't support it, and you don't even need it, this is actually, spoiler alert, this is more for the defense who has raised the motion to say, oh my God, they've alleged facts that aren't true. Now we need discovery to disprove by a preponderance of the evidence their factual assertions. It's almost like the courts don't want to just have a TCPA motion come in and the plaintiff automatically lose. That wouldn't be very just, would it? Would it, you idiot? So yes, the courts will consider other things than what's in the pleading. Greg, you know what would have been helpful? Greg, you're a lawyer. Cite the rule. Cite the statute, or cite a case. What's lacking from all of your assertions about Texas law? A citation. All right, let's move on. Additional findings. Let's see what this says. At the request of a party making a motion, so this is defendants, the court shall issue findings regarding whether the legal action was brought to deter or prevent the moving party from exercising constitutional rights and is brought for an improper purpose, including to harass or cause unnecessary delay or to increase the cost of litigation. Let's see. The court must issue findings under subsection A not later than the 30th day. So they can get the court to take judicial notice that the other party, the plaintiff, has acted badly. if the court finds in their favor. Appeal. Chronoflation says, oh, wait a minute. Let me read this one first. The Captain Z says, psychopaths are born, sociopaths are made. Psychopaths are born, sociopaths are made. You are neither of those things. You are something far more outside of the scale, a good man. Oh, thank you. That's too much praise for me, sir. But thank you. I appreciate it. So much more rare. And outside of the scale, a good man. I appreciate it. Chronoflation says, unrelated, but Tim Pool covered a journalist emailing Chase Bank about a Proud Boy shop using their payment service with 2 paragraphs of true but negatively framed details. Is this tortious interference with the contract? Depends on the Proud Boy shop actually canceling the contract or substantially impairing the execution of it. I don't know if they did or not. And it also depends on the state. That's a tough question. In Texas, it'd be a great case. Anywhere else, hard to say. An appellate, okay, if a court does not rule on a motion to dismiss in the time prescribed, the motion is considered to have been denied by operation of law, and the moving party may appeal. An appellate court shall expedite an appeal or other writ, whether interlocutory or not. This is the hardest part about drinking. It's reading some of these words. From a trial court order on a motion to dismiss a legal action under 2703, or from a trial court's failure to rule. So if they dismiss for lack of timeliness, it can be appealed. And it should be an expedited order because we have to get back to the case, right? It's an expedited order, so it has to happen right away. Next. Damages and costs. If a court orders dismissal of a legal action under this chapter, the court shall award to the moving party court costs, reasonable attorney's fees, and other expenses incurred. So yeah, this is the biggest risk in a defamation case in Texas. This is it, right here. Sometimes it's the biggest risk of a TI case as well. Sanctions against the party who brought the legal action as the court determined sufficient to deter the party who brought the legal action from bringing similar actions described in this chapter. If the court finds that a motion to dismiss filed under this chapter is frivolous or solely intended to delay, court may award costs and reasonable attorney's fees to the responding party. That's interesting. It's unlikely, but it's possible for Vic to prevail on a TCPA motion and then to win fees based on it. We'll see. Probably not going to happen, but it's possible. Exemptions. This chapter does not apply to an enforcement action that is brought in the name of this state or a political subdivision of the state by the attorney general, district attorney, a criminal district attorney, or county attorney. So you can't do a TCPA slap down of a criminal charge that violates your free speech. You have to do that in a different way. You do that by a 1983 claim in federal court. This chapter does not apply to a legal action brought against a person primarily engaged in the business of selling or leasing goods or services if the statement or conduct arises out of the sale or lease of goods, services, or an insurance product, insurance services, or a commercial transaction in which the intended audience is an actual potential buyer or customer, so that doesn't matter. Chapter does not apply to a legal action seeking recovery for bodily injury, wrongful death, or survival, or to statements made regarding that legal action. And does not apply to legal action brought under the insurance code or arising out of an insurance contract. So there you go. None of these apply to this case. And then construction. How do you apply this, they say? This chapter does not abrogate or lessen any other defenses, remedy, immunity, or privileges available under the constitutional, other constitutional, statutory, case, or common law rule provisions. Chapter shall be construed liberally to effectuate its purpose and intent fully. So again, the purpose and intent is to stop frivolous speech-based lawsuits while allowing properly wronged parties to pursue valid legal matters. So that statement goes both ways. Not sure if Greg does. Okay, that's the entirety of the Texas Civil Participation Act. It is pretty basic. it is actually being it is being modified. It has been modified by the Congress of Texas in this session. I believe the governor will sign this law or sign this into law. The modifications are not really relevant to Vic's case. There was some rumble that Vic might have an interest in withdrawing this pending those changes and would refile in September. The changes that I saw probably don't merit that, but I'm not a Texas attorney, and I am certainly not Vic's attorney, so I can't comment on whether or not that would be wise. My read of it says there's very little impact. I don't know what Beard, Harris, Bullock, and Hughes' read of it is. If they determine that it would be better for them to withdraw the action and refile after the law changes, I think in September, that might be something worth doing if it would defeat the possibility of the TCPA action. Again, from my read of it, I don't think that would be the case, but that's a possibility. I just want to put that out there and prepare people for that possibility, but I don't think it'll happen. Okay. So, thankfully, someone sent me this. T. Greg Doucette, his problems with the case. Oh, it was right before the case is going to lose thing. Again, guy tweets so much, it's literally impossible to find this stuff for me, live. Me, a boomer who can apparently Photoshop a logo onto a wall that is just already there. I don't know. Apparently, and if you don't know the story, there's a certain fat cosplayer out of Houston, Texas, who is absolutely disgusting and revolting and so ridiculously irrelevant now that she's losing Twitter followers. Whew. That must be embarrassing for you. And you know how you know she's losing Twitter followers and losing the grip on the narrative? She came out to address me on Twitter today, something she hasn't done in, what, a month? A month? Hasn't addressed me on Twitter. Yet today did. Why? Why is all this happening right now? Has that crossed anyone else's mind? Why is this happening now? And all at once. Right? So we have a penis-shaped lawyer. We have an idiot lawyer. Both of them admit to making statements about this case, not having read the documents, not being familiar with the factual scenario. Oh, and totally not caring. Like, he just totally doesn't care so much that he tweeted about it like 100 times. But he totally doesn't care. Totally not interested. Totally don't care. Right? Right, Akiva? You boring pile of trash. Totally doesn't care, but he's posting about it now. But I totally don't care. I'm gonna keep posting about it, but I'm just not gonna care a little harder. Okay? Two random nobody lawyers come out, not in Texas, no connection to the case, but they come out and they come out hard on this, right? Tweeting to all of their friends as fast as they can, trying to get this to Popat's radar, trying desperately. Now, there's two things. This is coincidence, and these two guys are so thirsty for some Twitter attention that they go to it. Now, if you look at Greg's Twitter metrics, you might notice that he was also losing followers over the past couple days, over the past month. Really needed something to bring a boost. And he got about 350 followers today on Twitter. So good job, Greg. Good job. You did it. You gained almost as many followers as you tweeted. That's good. It's a good thing. A 1-for-1 tweet to follow ratio. It's fantastic. I'm proud of you. Proud of you, son. Akiva, I haven't looked at his metrics at all. Could be coincidence. Oh, and the guy who did the video saying the case is frivolous, that guy has no following anywhere. And if you look why, you could look at his picture, he looks like Kevin from The Office, but farther on the spectrum and less funny. So who knows what they're doing there, trying to increase their social media presence, or that's one option. Second option, we know Shannon McCormick tweeted T. Greg Doucette and sent him the stuff. I don't know if Shannon McCormick is a Patreon of T. Greg, but he says he's one of his favorite lawsplainers, which indicates to me that maybe he is a Patreon or maybe he's communicated with him in the past. I don't know. But Shannon McCormick has a history of being stupid, goes to this moron. Someone else tweets Akiva Cohen, goes to that dummy. And they, together, try and spread this out amongst people who are not in the anime community, amongst other lawyers, out of context, to go ahead and go after Ty and his firm's reputation. That's fine. Right. And mine. But my reputation is completely irrelevant to all of these people. And that's where I would prefer it to be. Thank God, rogue scholars like Greg Doucette are not sucking my e-penis. Because thank God I don't have a dummy like that thinking that I'm smart. That would be the biggest insult I could possibly imagine, would be any of these guys. Like, I shuddered a little bit when Casey had to say in court that my content was entertaining, because based on Casey Eric's filings, I'm a little bit offended by that. But if either of these guys thought I were credible, I might Minecraft myself immediately. I don't listen to figs, okay? And I don't want their figging opinion. Oh my God. Ugh. Ugh. But yes, so my reputation amongst that crowd means literally nothing to me. I'll take real people over desperate, thirsty Twitter lawyers 10 times out of 10. But anyway, all of this happens. Mars Girl and Pridemore come running. Soye and Rial come out the woodwork. Shannon McCormick is jerking it so hard to the fact that he alerted to this. Therese is paying attention. No one's paying attention to Therese, but Therese is paying attention. All of these people, all on the same day, come out the freaking woodwork for this, right? They are so happy to have someone inaccurately state the law and suggest that maybe they're not going to get bent over and reamed out by the law cock of Beard, Harris, Bullock, and Hughes. They're so happy to have that finally happen that they come out the woodwork. Or is it related to the fact that on Monday, discovery is coming? I don't know if you guys remember this, but Ty and Company filed their discovery document production requests with their lawsuit, which means that their deadline to respond to those document production requests is June 10th. All of that evidence that they have been promising is definitely there and swearing to God that they want public but just won't release it. Monday, they have to. Unless they contest the discovery on Monday. Now, what do we have? What do we have going up to discovery on Monday? Let's analyze this from a strategic perspective, from a PR perspective. Going into Monday, as of yesterday, these morons had no momentum. They had nothing. Started business yesterday. Had absolutely nothing. And they have statements on the record over and over and over. We want everything public. We want to provide all of the information, but we just can't. We want it to follow the legal process. Over and over, they have that statement. So, of course, on Monday, what are they going to do? Provide everything, right? They're going to provide all of the requested discovery on Monday. We're all going to be treated to a treasure trove of information about how horrible Vic Mignogna is and all of his flaws. That's all coming on Monday. They've promised over and over again that it's coming on Monday. Unless, wouldn't it be interesting if a couple lawyers came out and said the case was meritless and frivolous? And that got some traction. What if they needed some cover to object to the discovery request? What if they needed some lawyers to come out and say, yeah, this is definitely frivolous. They're not going to win. That'd be interesting, wouldn't it? Wouldn't it be really interesting to see an objection to the discovery request come out on Monday? I think that'd be very interesting. Now, I'll tell you personally, Beard Harris, Bullock, and Hughes has been expecting those pussies to object to the very specific and narrow limited discovery requests that they had. I mean, they are highly tailored discovery requests. They ask for specific documentation. They ask for documentation related specifically to Vic or the ongoing situations. They put a 2-year reasonable limit on it. 2 years, by the way, is completely reasonable in these instances. Under Texas discovery rules, they could probably ask for more, but they didn't. And these guys are on the record over and over and over saying that they're definitely going to make everything public. But what if they don't on Monday? Would this be the biggest big op in history? That'll be interesting. Well, look, we got these. Why would we give up information on a frivolous lawsuit? Right? Right? Is that coming? Why would we comply with discovery if it's a frivolous lawsuit? I don't know if they're going to do that. That would sure be a weird coincidence. That would sure be. I have no information on this. I was just thinking about it today. I'm like, this is really weird. This is really weird. These people couldn't get a competent attorney to look at this at all. They still haven't, by the way, gotten a competent attorney to look at this at all. Still haven't done so. They couldn't for the life of them. In all of this time, they haven't found a single attorney to agree with them until 4 days before discovery. Suddenly they've got 2 lawyers and they found some reason to suggest that that Ty Beard and his company are incompetent. They're just rogue bumpkin lawyers. Yeah, we'll see. I'll be really interested to see if they challenge discovery or not. Because if they challenge discovery, and especially if in their motion they cite that public perception of this lawsuit is swaying, that'll be really interesting, won't it? Won't it? We'll have to see. Julio Santoyo. My little sister just graduated from high school today and she's planning on being a lawyer. Any advice for her? The typical attorney advice to someone saying they want to be a lawyer is don't. Don't do it. My advice to you is, if you want to be a lawyer, do it for the following. Don't do it for the following reasons. Don't do it to make money. Most lawyers make a middle-class income. Okay? The majority of lawyers out there make middle-class income. Just look at T. Greg Doucette. Can't afford a CPAP. It's a joke and a meme, but really, your average lawyer doesn't make that much money, especially compared to the debt required to incur it. Now, you can, or required to acquire the license. You can make money. John Edwards, very successful attorney. You get into the right types of lawyering, you can make a ton of money doing insurance claims for like dead drunk drivers. I met a guy at a very expensive resort. He was an attorney in Texas, and his practice litigation area was, or not his litigation area, his practice area was people who died in very horrible accidents, right? Very specific, like a semi-trailer exploding. So you've got corporate liability, and you've got corporate insurance policies that are paying the bills, and you've got dead people who are making money, who were making money before they died. You've got multi-million-dollar claims, right? That's what this guy did exclusively. That was his practice area. Very cool guy. Made a fortune. Imagine if you get 30% or 33% of $10 million settlements whenever you get them. Because that's what the maximum payout is on a typical corporate insurance policy for a truck company, and where the driver like kills another motorist. $10 million. So you take 30%, that's $3 million. Your firm gets a cut, you get a cut. You make $1 million, $1.5 million. That's one decision in a year. That was all this guy did. Okay. So, yeah. Some lawyers make a ton of money. Other lawyers don't. Many lawyers do not. And if you talk to lawyers who you think might be rich or making a ton of money, you talk to them candidly about their income if they're willing to, they'll tell you they don't make that much. So there you go. Don't do it for money. Do it because you want to be an advocate for someone. Do it because you want to stand up for a specific principle like justice, or the First Amendment, or the Second Amendment, or the Eighth. I don't care. The Third, Fourth. Third Amendment is specifically. You really want to be that one Third Amendment lawyer out there who's definitely campaigning against the government quartering soldiers. Do it for the right reasons. But if you want to do it, go do it and love it. Enjoy it. Help people in a way that can't be helped anywhere else. What if she wants to be a super lawyer? Play Minecraft all day until you can't. All right. Let's address these Greg Doucette tweets, shall we? First, the victim can't prove actual malice. That's probably not true. That's why when you read the lawsuit, there are no facts alleging it. There's one conclusory allegation. No, Greg. The reason there's no facts alleging it is because notice pleading requirements under Texas Rule of Civil Procedure 45 does not require it. Let's pull that up. Texas Rules Civil Procedure. Hold on. Here's the Texas Rules of Civil Procedure. I'll bring them on screen. Boom. And yes, I'm going to zoom in just a moment. We need to just scroll our way down to Rule 45. Now, let me tell you about the Rules of Civil Procedure number 45. Rule 45, where are you? Oh my God. Here we go. Rule 45, definition and system. Pleadings in the district courts, district and county court shall. This is an imperative. It is a requirement. It is how things will happen. What is this? Oh my God. Good job. Thanks Jason Stroud for pulling that up. I don't know if I want to give that person any exposure. Here we go. Rule 45. The pleadings in this district and county court shall be by petition and answer. Hey, Shane, remember when I asked you how in God's name you bring a lawsuit other than by Summons and complaint. Petition is what they call it in Texas, but it's a summons and complaint. Remember, Shane, when you couldn't answer that because you're too stupid to answer how a lawsuit is brought other than by summons and complaint? It's not. There's no way to bring it other than by summons and complaint, you fat idiot. Go eat a shoe. Okay. It's summons and complaint, or by summons and petition in Texas. An answer. B, consists of a statement in plain and concise language of the plaintiff's cause of action or the defendant's grounds of defense. All right? This is a clause and it ends. That's important in legal reading. This is a separate clause. That an allegation be evidentiary, based on evidence, or be of legal conclusion, based on a conclusion not necessarily supported by facts in the complaint, shall not be grounds for objection when fair notice of the opponent is given by the allegations as a whole. This is different and reduced from the federal pleading requirements that I've talked about on this channel. In federal court, you have to plead following the Iqbal versus Twombly standard without conclusory allegations that a case is meritorious under the facts and law. You have to plead it specifically under the federal rules. The Texas rules are different and reducedly so. Okay? So in Texas, you plead providing notice of the causes of action, and that's in the or in the defense's case, they just provide the grounds of defense, which is why a general denial is, and then followed by affirmative defenses, is sufficient to sustain a defensive pleading. But an offensive pleading is just a statement that, if true, makes a prima facie case for the causes of action alleged. That's it. Period. 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 So Greg is going. You can see it in the language he's using. There's one conclusory allegation. That's actually okay in Texas. It's not okay in federal court. A conclusory allegation would be ignored in federal court, but in Texas, so long as the overall thrust provides notice of the defamation, you can go ahead and plead it. Here's the problem with what Greg is saying. Because Greg is mentally deficient or just not educated on Texas law, either possibility is open at the time. Greg, you don't have to plead the facts of actual malice, because Texas realizes that the public figure doctrine is a fact question, not an automatic assertion or assumption. So Vic might be a public figure. Vic might not be a public figure. Vic does not have to plead the facts in regards to actual malice, although they can probably make a case of actual malice based on just the sheer volume that they're tweeting and the fact, let's not forget this, because there's malice, and then there's actual malice, which is a legal term. What does the legal term actual malice means? Knowledge of the falsity or reckless disregard for the truth. One of those two things. How do you prove actual malice? Oh, I don't know. Maybe you take people who purport to be directly related to Vic, as in really good friends, for 20 years, asserting things that turn out to be false. Maybe that's how you prove actual malice. You say, I was great friends with this guy and at conventions with him, but he acted inappropriately in these specific ways. And then you say, wait a minute. No, he didn't actually do that. And if you were the friend you purported to be, and if you were with him at the conventions you purported to attend, you would know that these are false. Or conversely, if you were purporting to comment on activity that happened at an event that you were not present for, but are in the industry and can provide could have reasonably researched this information, and yet you didn't. That's a reckless disregard for the truth. If you call Vic a rapist but can't produce a single person that you allege he raped, that's reckless disregard for the truth. If you say he's a rapist and can't provide the rape, that's either false or a reckless disregard for the truth, and you have to know that. You have to know that. Because if you're asserting that he's a rapist, you better have a rapee. Can we stop calling them rape victims and start calling them rapees? Like it's a land transaction or something? That would be funnier. You have to have a rapee if you have a raper. So if you're going to call someone a raper, you better have a rapee. And if you don't, then it's false. Period, you moron. If you call him a child molester, you have to have a child molestee. You don't. If you call him a sexual assaulter, you better have a sexual assaultee, someone who was sexually assaulted. Where are the police reports proving the sexual assault? Sexual assault is specifically defined and codified in Texas law. You can't just say someone sexually assaulted someone. That's not an insult. That's a factual statement. Greg? But you don't know the facts, do you, Greg? Because you didn't read them, did you, Greg? Because you're a drive-by bit rate attorney. Right, Greg? Right? Phoenix Aram says, hey, Nick, it's your favorite neighborhood comic book guy. I asked before, but you never really answered. But given you like juicy drama like Russell Greer loves suing people, continued. Oh, I'm intrigued, Phoenix. I hope you tag me in whatever's next. Let's focus on number 2, shall we? Second, if what's in the complaint is representative of these 400 pages of tweets, they're all... Greg. Let's pull this up. I can't take it. Hold on, I'm trying to find Vic's complaint. I know I have Vic's complaint somewhere. Oh, goodness. Plaintiff's original petition. Here we go. Let's see what's in this. Oh my goodness. Facts. Let's analyze this tweet logically. Because a voice actor has performed the voices of animated characters for over 22 years, mainly in anime productions. Vic does not physically appear in these productions, only his voice is used for English dubbing. Monica and Jamie are also voice actors. Both have worked for Funimation. Ronald is Monica's fiance and either a Funimation agent or employee. Funimation primarily dubs Japanese anime properties into English for distribution within the United States and provides streaming access, subscription services to those properties via their website. Phoenix Arm says, can you cover the Prime Minister of Canada and the SNL Lavalin case? It involves tortious interference with contracts, and given Justin's love of white knighting the women's, it would make a fun stream. Can you, Phoenix, can you please email me that? Because I am not going to remember. I'm really not. I'm sorry. I would love to remember that, but can you please email me that? And any links to get me started would be great. For example, Vic was cast as a voice for Broly, lead character in the fantasy martial arts film Dragon Ball Super Broly. Also included Monica. In addition to his work, blah, blah, blah. January, the day Dragon Ball Super Broly released in the US. Monica liked and retweeted a tweet of someone, Han Leia, blah, blah, blah. Liked and retweeted 2 tweets by Kalen Saucedo that accused Vic of great volumes of sexual misconduct. Urged Funimation to reconsider hiring Vic as a voice actor in the future and initiated the hashtag #KickVic. Repeated attention that they gave caused their tweets to go viral. About the same time, one or more defendants began actively defaming Vic. Barely a week later, Tammy Danbo informed Vic that she's investigating 3 allegations, blah, blah, blah. Let's get to those tweets, right? Fallout from the defendant's action was swift. January 18th, Phoenix Fan Fusion canceled Vic's appearance. January 26th, Ronald tweeted that Vic was a predator. A charge Ronald would repeat in at least 15 more tweets. Shortly after, the Ranger Stop convention canceled Vic's appearance. So here is, by the way, let's talk about notice pleading. Here's a fact that, if true, proves defamation. Period. It does. This fact, if true, proves defamation. This is a prima facie case. Period. Ronald Toye tweeted, Phoenix Fan Fusion canceled their appearance. December 29th, Denbo and another Sony executive informed Vic that his employment with Funimation was terminated during the Denbo's investigation. Now let's find the date. It doesn't say the date there. That's annoying. January 30th, both Anime New York City and Anime Milwaukee conventions canceled Vic's appearances. January 31st, tweets. Ronald claimed to know at least 4 assaults by Vic and crowed, I am glad to see conventions canceled. That's defamatory. At least 4 assaults. This is not an insult that Vic is an assaulter. This is statements of fact. I know of at least 4 assaults. I'm glad to see conventions canceled. Kawaii-Con cancels the appearance. That's damages. If we weren't clear before, this is the damages element related to the tortious interference. Or not to the tortious interference and the defamation. He can argue both. Ronald tweeted he personally knew that Vic was guilty of at least 4 accounts. That day, Kamehameha Dallas convention canceled Vic's appearance. Vic was re-invited. Although that was a pain. Tweeted Vic needed to prove himself not to be a predator. This is defamatory, by the way. He's not using predator as an insult or opinion statement. He's using it as a factual assertion, Greg. These aren't protected opinions. They aren't protected insults. He's not calling him a cuck or a soy boy or a penis head like you. He's not calling him a reject who had to crowdfund a CPAP. He's not calling him someone who barely passed the bar exam. He's not calling them any protected insult. He's making a factual assertion about Vic. Period. February 4th, Ronald tweeted multiple times that Vic was a predator, called Vic a perpetrator, criminal, and asserted let me tell you, as a former foster parent, if you call someone a perpetrator, you're alleging that they sexually assault on children. Period. That's what perpetrator means from a foster parent. What do you think Ron Toye's meaning was? Was this an insult or a fact statement? Oh, let's just answer that. There are over 100 accounts and still more to come. Fact statement. Here it is. He is down because it took advantage of girls, buddy. How about get a grip on reality and stop harassing people? Over 100 counts and still more to come, and you defended this sack of shit. Get a life. This took advantage of girls, get a grip on reality and stop harassing people. 100 accounts and still more to come. Those are fact statements. It's not passing insult. Greg, God, you're dumb. February 5th. Funimation informed blah, blah, blah. Ronald again tweeted that Vic is a predator. So here we go. Ronald tweeted over 100 women and made accusations of assault. The allegations against Vic were corroborated in that there were mountains of testimony, fact statements, Greg. Funimation have proof. That's why they fired him. Fact statement. This is a fact statement. Here's the really funny thing, Greg. If Funimation, if one of their defenses is we actually didn't fire Vic due to sexual harassment stuff, so our tweets aren't defamatory, if they say that, Toye has committed defamation. Monica tweeted, it happened to me. I'm only one voice in a sea of many. He's hurt enough people. Fact statements. He's a sick man and needs help. That might be opinion, but in the context of the overall statement, they're saying he's sick and needs help from his sexual assault. Later that day, Jamie attempted to rebuff those questioning the veracity of Monica's post. Yes, I want his head. I want his balls. This is malice, you idiot. She's asserting her willingness to lie. I want him to feel an ounce of the pain he's caused others and then effing choke on it. I want you to take his dick out of your ears so you can actually hear reality. But you know, that's just me. She's asserting right here her willingness to lie. You put that before a jury or a fact finder and say, Judge, you want clear and convincing evidence that this bitch is willing to lie? Here you go. Here you go. Look at her saying she wants him to go bad. You think this person making this statement in public about a former friend isn't willing to lie? I mean, I guess. What about innocent until proven guilty? Works in a court of law. Sometimes name and shame is the fastest way to the courtroom. Here you go. Name and shame. Is she willing to lie? I don't know. Is she? Is she willing to make up a false story about Vic? I'm pretty sure that would constitute the malice you're looking for. Jamie tweeted that Vic had assaulted her several years prior by grabbing her hair and whispering in her ear. In the last week or so, I've heard accounts of doing this exact thing to a half dozen other women that I personally know. You personally know them, huh? How would they have gotten that story? Apparently, Vic only does this to women he knows. February 11th, Funimation made its investigation public, blah, 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 blah. I just want to point out that Greg is saying disclosed facts. The facts were disclosed by the parties making the defamatory statements, Greg. That doesn't make them disclosed facts. They're not protected opinion. Like, look. Let's take a hypothetical here. Okay? Because here's what we're going to say. I called up Greg's employer. Better yet, Greg's on Patreon. I call Patreon. Hey, Patreon. Greg Doucette raped hundreds of girls. Greg Doucette raped girls all over the planet. He's a raping raper who rapes repeatedly. You know that guy in Blazing Saddles who really likes rape? Greg loves rape. He's the biggest rapist. He's on Patreon. Greg is the raper he rapes rapists and their victims. Greg finds rapists in the acts and then rapes the rapist and then rapes the rape victim. That's how much Greg Doucette loves to rape. He is the rapiest raper who has ever raped. Actually, he's going to rape you if you insinuate that you rape harder than him, because he rapes so hard that no one around Greg Doucette has not been raped. If I call up Patreon and say that, okay, and then Patreon cancels Greg's rapist podcast, and then they say, we received information that Greg is a rapist, and then I go out on Twitter and say, by the way, Greg Doucette, look at Patreon canceled this rapist for being a raping raper. I'm not giving a protected opinion based on facts disclosed. I'm just repeating my initial defamatory facts, you fat idiot. The facts disclosed are admittedly disclosed by the defaming parties, Greg. Greg! You can't defame someone and then when someone else says something, say, oh yeah, look at this other person using my defamatory statements to continue the defamation and then say it's protected. You're the originator of the defamatory statements, you moron! How are you this stupid? I don't get it. Wait, I do. You don't know the facts, do you, dummy? You're commenting on something without the facts. But you're a real internet lawyer, right, Greg? Let's move on to allegation 3. Third, they have to prove damages were the direct result of the defamatory statements alone and not things like entities using Google or being risk averse in who they invite or true statements made by others, etc., etc., etc. Well, Greg, let's have a thought process, shall we? These people, and you've commented on this, which is even more embarrassing, and so has Akiva Cohen, have said, well, it looks like Vic's thing has been an open secret for years. Okay, let's take the assumption, Greg and Akiva, best trial attorneys on defamation you can possibly find. Let's take the assumption that Vic has, for the past decade, been an open secret sexual predator at cons who have invited him every single flipping year for that decade when it was an open secret. Okay? Let's just go ahead and run with that argument. Let's see how it works out for you, shall we? If Vic, think through this, you idiot! If Vic has been an open secret offender for a decade and every single year all these big conventions still host him, they still host him even though it's an open secret, how in God's great name are you going to assert that these conventions suddenly decided to not invite him other than public defamatory statements by the defendants? How on earth are you going to make the claim that after years of inviting him, when all of this information was public, that the most recent defamatory statements that directly predate and predicate his uninvitings are not the direct result of those defamatory statements? You bald idiot! How are you going to allege this? What possible defense can you muster if he's been invited? Say, Jesus, Google shone down upon them, blinded the conventions and said, listen, your name is now Bing, and now you can understand that all of the stuff that you purportedly knew for the last fucking decade is real. Just now, because Google told them it was real, they hadn't had the open secret and complaint after complaint that's being alleged over and over. Just now, they all conclusively, by themselves, independent of any recent statements, suddenly decided. They all came to the light. Holy God, what a fucking coincidence, you idiot! You've set up the goddamn case for them. Of course it's a result of the defamatory statements. Literally, your argument is that everything that has happened for the past decade, they were fine with until now. Oh, I don't know how they could prove it because I'm just a dumb internet lawyer. You moron. Oh my God. Please help them. Please bring this to court. Please go up in front of the judge. I dare you to go in front of that judge and say, Your Honor, this has been an open secret for a past decade. Everyone in the industry knew it. There's statements all over the place that all of these cons knew about. And they invited him again and again and again and again and again. Over repeated invites to the same cons over and over and over. And they're like, thank God we have Vic. They've solicited promotional commercials from the alleged repeat rapist over and over and over. Please. Yeah, actually, he was at SakuraCon, A-Con, San Diego, or God damn it. He was at Phoenix Fan Fusion. He was at all these conventions. He was at SuperCon, RaleighCon, KamehaCon, all of them. He went to all of them multiple years in a row, over and over and over. They all knew about it, but he went over and over and over. And actually, shockingly, on January 29th, and then on February 1st, and then on February 3rd, and February 5th, 13 conventions randomly out of nowhere with no prompting from anybody all came to the exact same conclusion that they had hired a serial rapist for the past decade, and they all decided just now by sheer coincidence. Please, dear God. Yes. Yeah, Judge, actually, it's an open secret. All of them just came to the realization on the same week. They all on the same week came to that one realization, and they all decided on the same week, independent of everything else. They've never seen a statement from Ron Toye. They weren't contacted by Monica Rial and her agent. No one at Anime News Network spread this around. Mars Girl didn't tweet anything. Han Leia didn't tweet anything. None of them saw anything. Anime News Network, IO9, none of them made any statements about this, and none of them based it on statements from other people. None of them leaked the fact that there was an investigation prior to the investigation even fucking commencing, much less being finished. None of them did that. Oh, I mean, sure, they've got text from Ron Toye alleging specifically that, but none of them did it. Not a single one of them did it. No, all of them came to this based on information they had from other people. It's not the direct defamatory statements over and over and over by the defendants. It's not the statements made in private or in public. It's everything else that they ignored for a decade. Just trust me. Please, Judge, just trust me. Look at me. And please, if you can, donate to the GoFundMe so I can sleep at night for my CPAP. Judge, I know judges make a good salary. Please do it. Please. That's your argument, you weird. What in God's name? You asked how I passed the bar exam? Oh my God. This is your statement. This is your argument. This is what you're resting on? I don't know how they would prove that, Greg. Maybe you can enlighten me. I welcome it. These are the dumbest people I've ever met. Not because he's an incompetent attorney. I have no idea his competence. He alleges that he does criminal defense. I'm sure he's good at it. I would guess. He alleges that he does defamation. Might be good at it in North Carolina. I don't know. But to take and comment on this case without being aware of the facts, to run with this assertion, to assert publicly and definitively that this case will lose based on your 3-step process, when every one of those steps, hey, I'm an incompetent attorney, remember? An incompetent internet attorney can defeat all 3 of your 3 problems while drinking, off the cuff, without preparation, on a live stream. And you're going to go into court with competent counsel and have them argue opposed to you? You're going to comment that publicly You're going to rest your laurels on that? I have been covering this case since February. I have extensive knowledge of facts, both disclosed and undisclosed, publicly. I have done some research on Texas law. I'm certainly not an expert, would never sell myself as such. And I, an unprepared internet lawyer, can defeat every one of your problematic assertions with the pleading, citing to rules, citing to facts, or citing to case law. On the fly. And you're going to publicly make statements about it. That's why you're a dumb attorney. Not because you're incompetent. Probably very good at your job. I don't know. No reason to believe otherwise. But you're certainly stupid at talking about this case without the facts. Because this case is fact intensive. All right. I'm done talking about this idiot. Holy Christ, Patrick Thompson. This is for that epic rant. Hey, thanks, buddy. Thank you. But, wow. I'm sorry. I've been thinking a lot over the last 2 days. Let's uplift the stream and be happy that a pedophile has been caught, shall we? Where do we go? Hold on, I'm pulling up the try and find an trying to find a good alt-right news source for this one. I want to get the case documents up. Come on. Oh my gosh, all these sites want ads. Eric sent via Streamlabs. Thank you, Nick, for the hours of entertainment, bud. Hashtag no homo. Hey, my pleasure. Gay and still at large. Is this an apology / thank you for my inexplicable erection? Okay, let's bring this. So here's the complaint. We're gonna go through this in a minute, and I do unironically, I'm gonna put a trigger warning on this. Okay, I'm not someone who believes in things like trigger warnings for like potentially, you know, content that might remind someone of something. I don't get down like that. Like, especially in colleges or whatever, you're there to challenge what you know about reality. You're there to learn about stuff. And, so I'm not a big fan of those, but in this case, I'm going to issue a real trigger warning, mainly because, the subject we're going to cover and the words that are in the complaint they're the worst humanity has to offer. Okay. They're the worst. These are the worst people. And it's important. I wanted to talk about this specifically in a video that addressed Vic. This is what these people are talking about. They're calling Vic a predator. They're calling Vic a pedophile. They're calling Vic all sorts of sexual assaulter. They're lumping them in with these degenerate piles of trash. It's important to remember the true depth of what the factual assertion of pedophile and predator mean. Okay? First of all, they mean you look like that. And if you look like that, very sorry. Let's go through our alt-right news source. This is from theblaze.com. The Blaze. Oh, wait. 2 super chats. Diablo says, hey, Nick, I'm hella late and more gay than a bag of sour gummy worms. Looked like I missed a rant. Maybe. Elisol17 says, as the amazing Lucas would say, oh my goodness, Nick Rekieta, you definitely deserve a Tommy point for that Geiga epic preaching the truth rant. Straight up fire. All right. I only did that because I get to rest my voice tomorrow. Just kidding. Just kidding. Here we go. I'm no longer a foster parent. We were a long time ago. Peter Bright, a progressive feminist and prominent tech journalist, has been arrested on charges that he was allegedly soliciting sex with a minor. Lovely. Bright, who wrote for Ars Technica and appeared in videos for the company, Ars Technica being a Condé Nast-owned company. Remember, they don't just employ Heather S. They also employed Peter Bright. Was charged after he allegedly arranged to molest a 7-year-old girl and 9-year-old boy. He was instead arrested by an undercover FBI agent who he contacted through an online fetish social media platform. He allegedly sent the agent graphic photos of himself, penis picture, and also an STD test to prove he would not give the children any diseases. Look at how thoughtful he was. Remember how thoughtful he was. The criminal complaint has graphic descriptions of what Bright told the agent, including his claim that he had been molesting an 11-year-old already. Bright, who is 38 years old, tweeted under the account Dr. Pizza, where he self-identified as a polyamorous, pansexual, and pervy in his profile. I guess he should also have said gas averse. He often used the account to tweet vile insults at President Donald Trump, including one accusing the president of having incestuous feelings for his daughter. Projection. Maybe. It's unacceptable to call Trump a mother effer, Bright tweeted in January. As we all know, it's one of his daughters he wants to F, not his mother. Another online missive, he disparaged Trump supporters, saying, F Caitlyn Jenner and every other Trump-voting scumbag. Ars Technica has indicated that Bright no longer works for the company. Charges were filed at the U.S. District Court for the Southern District of New York. Bright is being detained without bail. Let's find out why. Why would he be detained without bail? Here we go. Again, this is 6 pages. It's going to get into it very quickly. If you are not comfortable with this type of content, I 100% understand. This is gross. This is gross. In the real sense of the word, not in the Twitter social justice like gross or creep or yikes. This is the real gross, the real yikes, and the real nasty stuff that is in the hearts of some degenerates. All right, United States of America versus Peter Bright, Southern District of New York. Elizabeth Jensen, being duly sworn, deposes and says that she is a special agent with the Federal Bureau of Investigation. She charges as follows. So this is an FBI agent alleging under oath the circumstances to which led to the arrest of this guy. Count 1. I think this is the only count currently. I'll tell you, they're trying to find the 11-year-old that he was allegedly molesting, and if they can find that 11-year-old, they will bring the hammer down significantly. I would start with his nieces and nephews and any close relatives and friends. And if you're a close relative or friend, or a sibling, or there's a niece or nephew, if you know this guy and there's an 11-year-old child in your life, immediately get them to therapy, for God's sakes, and find out if they're the one that this sick, disgusting person was abusing, they're going to need all the help they can get with the rest of their lives. And you can't state that enough. From on or about April 18th up to and including on or about May 22nd, in the Southern District of New York and elsewhere, Peter Bright, the defendant, willfully and knowingly did use a facility and means of interstate and foreign commerce to persuade, induce, entice, and coerce an individual who had not attained the age of 18 years to engage in sexual activity, for which a person can be charged with a criminal offense, and attempted to do the same. To wit, Bright used computers and or telephones to communicate with an undercover FBI agent about arranging to engage in sexual activity with a purported 9-year-old boy and 7-year-old girl, and attempted to meet with the boy and the girl to engage in sexual activity in violation of New York penal law sections a whole lot. And if you check my, I see you guys mentioning Pizzagate on in the chat. If you check my most recent tweet on Twitter, you will find where you will find that that he has suggested that he's talked about Pizzagate. We'll say he's talked about Pizzagate. You can go check that out. The basis for my knowledge and for the foregoing charges are in part as follows. I'm a special agent with the FBI and have been so employed for approximately 4.5 years. I'm assigned to an FBI squad charged with enforcing federal laws, prohibiting child pornography and other forms of child exploitation. As such, I've worked on numerous investigations and prosecutions involving minor victims and the adults who victimize these children. This affidavit is based on my personal participation in the investigation of this matter, as well as on my conversations with other law enforcement officers, and my examination of documents, reports, and records. Because this affidavit is being submitted for the limited purpose of establishing probable cause, it does not include all of the facts I have learned during the investigation, or the contents of documents or actions, statements, or conversations of others are reported herein. They're reported in substance and in part, except where otherwise indicated. That means that they have you know, they are purporting to have additional information and not just this. Hold on one second. I got a mild point of order from Percy Tyrone Beard about an hour and a half ago. He updated me on a rule in regards to the pleadings, and I want to talk about it real quick. So we'll get back to the document, but I want to talk about it real quick. If the pleadings are challenged via special exceptions to the pleadings, which if you remember reading the defendant's answers, they were, then according to Ty, they can replead. If they're challenged by special exceptions to the pleadings, they can replead. So if their petition is deemed not sufficient, they can actually modify the petition by motion to the court and cite the fact that there are special exceptions to the pleading listed and go ahead and get to replead them. So Casey Eric did that. He cited special exceptions to the pleading. So even if the pleading were insufficient, they could replead it. However, of course, their pleading is not insufficient. So there you go. Malidius says, insert witty comment. And then Phoenix Aurum says, Keck and I are on the case, Chief. Please say it with a 1950s New Yorker / Brooklyn accent. I'm off to bed. Good night. Hey, Keck and I are on the case, Chief. Hopefully, I don't know if that got it or not, but we'll talk about that later. Okay. 3. Based on my review of communications exchanged between an FBI agent acting in an undercover capacity, UC1, and an individual later identified as Peter Bright, the defendant, I have learned, among other things, the following. On or about April 17th, 2019, UC1, posing as a mother of a 9-year-old boy and 7-year-old girl, posted a public message on an online social media fetish platform called Kink D, seeking to chat with people who are, in sum and substance, interested in teaching her children lessons about the, quote, birds and the bees. Now, I've talked before about a particular Twitch streamer who was arrested for a very similar thing. The messaging from the FBI was very, very similar. It's actually really interesting to see both of these people picked up for the exact same thing. Where a fake mother of fake children is soliciting for people to teach their children about sexual activity. And these disgusting people, this is what they're looking for. Think about that. Oh my God. They're looking for this. On or about April 18th, 2019, a Kink D user by the handle Random Anon, later identified as Peter Bright, the defendant, responded to UC1's Kink D post. On or about May 1st, 2019, UC1 replied to Bright on Kink D, "My princess is 7 and my Prince Charming is 9. Bright suggested moving the conversation to text messaging. On or about May 14th, 2019, Bright and UC1 decided to continue their conversation over WhatsApp, a messaging application for cell phones. In order to communicate using WhatsApp, Bright provided UC1 with a particular cell phone number linked to his WhatsApp account, the telephone number. Probably hacked though, right? Oh, I don't want that on screen just yet. Because for this one, need a little more. About to get a little awful, y'all. Okay. Between on or about May 14th, 2019 and on or about May 22nd, 2019, Bright engaged UC1 in discussions regarding Bright's ongoing sexual experience with an 11-year-old girl, the minor's previous sexual experience, and the possibility of Bright meeting UC1 and the minors in person in Manhattan, New York, to engage in sexual activity, including Bright penetrating the girl with a finger, a toy, or his penis. The following are excerpts from the exchange between UC1 and Bright on WhatsApp. Here we go. Undercover. When you last teach a little girl. This is actually something that's awful about this. I've noticed. They write. The undercover FBI agents write at a very uneducated level. That's not like an accident, right? I don't want just anyone teaching them. Bright says, I have a girl I've been teaching off and on for a couple of months now, but she's in the Bronx, which makes the logistics much harder. As old as my princess, a bit older, 11. Ah, okay, a little bit. What are you good at teaching? We have started the basics with the girl. Bright says, I think masturbation and anal sex are probably my favorite subjects. Helping girls find those special places to touch, it's very rewarding. There's a gap in the communication here that's not listed in this document. Undercover says, you thought about what kind of lesson you would like to start with. Anything excite you, smiley face. Where have I seen a smiley face before? Bright says, really depends on their experience, but I'm thinking maybe something involving foreskin is the way to start. Oh, God. That's your go-to? Really? Bright says, do you want the lessons to be heteronormative? This should have been your first clue that you're not talking to some rando. Oh, wait, no, wait, sorry. Bright says that. Do you want the lessons to be heteronormative? Sorry. Undercover says, sorry for my ignorance. What do you mean by that? Okay. Sorry. Their cover is not blown by them knowing the definition of heteronormative. As opposed to what? Bright says, does the girl eat flowers and the boy suck snakes? Yep, I'm quickly reacquainting myself with the death penalty. UC1 says, I'm wondering how you teach her how to pleasure herself and you. Bright. Some girls at a very early age discover that it feels good to rub certain bits. But otherwise, help her discover that herself, touching or vibrating her clit, putting a finger inside her may be a very tiny toy. Bright says, how to hold my snake, showing her where the most sensitive parts of it are, the parts that feel best to lick or rub. Bright says, how to take it in her hand and the kinds of motion that feel good. UC1 says, yes, helping her discover all the best parts are super important and can be tricky to master. Bright says, yes, gentle touching and teasing. Is the girl a virgin? UC1 says she had the tip inside but not the whole cock. Bright says, okay. UC1 says, does that excite you, lol? Bright says, yes, but I think the tip might be all I can manage. Oh, of course. Yeah, you're a raging hung horse, you disgusting pedo. Based on my review of the text conversation between Bright and UC1, I understand snake to refer to a penis and flower to refer to a vagina. On or about May 15th, Bright sent UC1 2 photographs documenting his test results for several sexually transmitted infections, including HIV, Hep B, Hep C, and gonorrhea. On or about May 16th, Bright sent UC1 2 photographs of himself. Based on my visual inspection, one of the photographs appears to be identical to the profile pictures associated with Bright's WhatsApp account and Bright's Kink D account. On or about May 17th, during a recorded telephone call between UC1 and Bright, Bright stated that he was available to meet on Monday, May 20th. UC1 and Bright discussed the first lesson, and Bright explained that he would want to meet the minors, have them introduce themselves, have them show him what they already know, and teach them about the foreskin of his penis. On or about May 19th, 2019, Bright sent UC1 a photograph of his penis. On or about May 20th, Bright and UC1 rescheduled their meeting to Wednesday, May 22nd. Based on my review of records from T-Mobile USA, I learned that the customer name associated with the telephone number is Peter Bright, the defendant. On or about May 22nd, Peter Bright, the defendant, met UC1 on or about Hudson Street in Manhattan, New York, and was arrested shortly thereafter. Based on my visual inspection, Peter Bright, the defendant, is the same person as the individual in the photographs. Peter Bright, the defendant, was thereafter advised of his Miranda rights, waived those rights, and agreed to speak with law enforcement officers. Among other things, Bright admitted to having chatted with UC1 regarding engaging in sexual activity with the minors. Well, there goes his defenses, right? The subscriber name associated with the telephone number is another individual with the surname Bright. Storm Knight MD says, scary thing is there are people out there that want to normalize this sick behavior as a fetish. Children can't consent. This sickens me to no end. I really can't keep my range in Minecraft with this. Wherefore, the deponent respectfully requests that Peter Bright, the defendant, be imprisoned or bailed as the case may be. There you go. That's the real evil of the world. That's the real disgusting people of the world with real victims. With real victims. Not a flipping hug. Not a hug. Not a kiss on the cheek. Not 6 years later deciding that that kiss on the cheek is what really traumatized you and prevented you from being a prominent yaoi artist. Or whatever. Not standing in an elevator with someone and determining that the other person must be uncomfortable, so therefore you need to defame a man. There are real victims, you disgusting people. Queen Nida says, my armor is contempt, my shield is disgust, my sword is hatred, in the emperor's name let none survive. Let the furries and the lolicons be hung and their bodies burnt. Hold on one second. Death is the only option, no empathy, no mercy. That's why I brought this case up, guys. One, it's timely, right? Just happened. Just happened. Arrested on the 22nd. This became public today. It just happened. 2 is there are real victims. People who are really assaulted. Not by a jelly bean story. Not by someone fumbling through like a pickup line. Not by a consensual kiss that you decide 6 years later that you regret. Or something like that. All right. Let's hit the rest of the super chats and call it a night. I apologize again for this content, but it's important to remember. It's important to remember that these people are out there. If you have children, guard them. Oh my God, guard them. Guard them. I'm going to go through the Streamlabs first. 3 hours. Flex tape. Related nominally to Kick Vic, but it seems Rooster Teeth wanted Ruby for themselves. Uses virtue signaling platform to this end. Monty Alm's death may not have been an accident. Okay. Night of Hopex says, hey, Greg, haven't seen a bald guy get gangbanged like that, like last night since Lamar Odom lost that game with OKC back in 2010. Blackface Rekieta says, I'm beginning to believe Kick Vic since you lied to us, Nick. You said this Vic case was going to slow down. I should have already known not to trust you dirty lying lawyers. Lol. Knight McCuck. Storm Knight Indeed says, I just want them ended quick. I don't want to waste the effort of any torture. They don't deserve my time and effort. Night of OPEC says, hi, Greg. Rip that CPAP machine, buddy. No vacuum in the world can suck oxygen through the fat in that neck. Woof. Whoa. Night of OPEC says, hi, Shane. How does it feel to know that that one day your children are going to grow up and realize you're an idiot? I hope to God for their sakes they get more out of your DNA than you did, you fuzzy pear-faced looking clown. Jay says, they want to portray themselves as victims. They do. The Emperor says, good. Let the rage flow through you, Nick. And Night of Hopex says, saddest thing about Kick Vic and these thirsty boy lawyers is that many of them are probably only doing all this because their lives are empty. And this is the most they've ever mattered to anyone. Instead of forming meaningful relationships, they come after us. Phoenix Aurum says, Nick, if someone approached you with a case like you were reading out loud, would you still defend them if the money was good? No judgment with whatever your response is. I would provide them with a defense, but I would tell them up front what the defense would be. You need to plea out, right? The best strategy for this guy, assuming I would go through the procedural stuff because I do hold governments accountable. I do. I would go through the procedural stuff. I would check the procedure, the criminal procedure in my state, make sure it was followed appropriately, make sure they got all the process that was due to them. And if they did, with the same fact pattern, assuming there's not some other fact, but they've got admitting statements from the defendant, I would suggest their best option being to settle, exhausting all other options. Yeah, I'd take the case. Sure. I defend everybody. Even if I think that they're awful and disgusting, I defend them. But, yeah. There you go. Your DMs, I don't want to check my DMs. Oh my goodness. Anyway, I can't, I'm focusing on too many things. My attention span is waning really quickly. Okay. Back to it. Yeah, I would take the case, but I would tell them very openly and honestly what my defense strategy was. That's how I do things. I tell people, you know, based on what you've told me, based on the facts you provided, here's how I would approach the case. Here's what I do next. I encourage that person to not hire me. I then say, go talk to any other criminal defense attorney, get a second opinion. If I miss something, if my strategy isn't suitable for you, go somewhere else. I think something like 99% of clients hire me after that. Either because the other attorneys don't tell them what, don't contradict me, or because they like my answer better, or because they like the honesty that I provide. That's how it goes. So whether or not the person would hire me would be up to them. Little Lamb Adventurer, thanks for the donation. John Sargent says the offices of Twit and are now disbarred. Chronoflation says, hey, Nick, did you see the Tim Pool video about the journalists getting the Proud Boy website blocked from Chase today? Seems like tortious interference with business contract to me. I did not do that. Internet tab says the weekend has just started and is beautiful. Matt Field says hashtag law wonk. Yellow Flash 2 says have a shot on me. Thanks, buddy. King Explosion Murder says the Raptors are a game away from winning their first ever championship and against the Warriors of all teams, lol. Yellow Flash 2 says Gamergate 2.0 gamers rise up. Raccoona says this disgusts me so much, especially when I know that just because I like anime lollies, these figs would say whatever pedo-like drawings equal crime. Brendo K says let's go Raptors. Rocky Top Otaku says, I'll do an ab crunch for every super chat dollar. Good luck, buddy. Anthony Siebert, thank you. Excitable Boy, thank you. The Cape 88 says, I was wondering if you're going to bring on Greg, even though we all know how it will go, aka next Shane, lol. Greg would not be the next Shane. That's the dumb thing. I wanted to have a productive discussion with Greg. I really, really did. Turns out he's a bitch. Archie Ratsworth says, sipping bourbon and ginger ale in Australia. Popad is what got me interested in USA law drama, but I prefer to listen to YouTube lawyers like you. Hey, thanks, buddy. Legendary Super Saiyan E-Rock says, remember those Disney World Park tickets are still here for you and your family if you're ever in Orlando, boss. Yeah, that actually might happen sometime this year. I will let you know. Trivia Aficionado says, sorry, life's been rough lately. Praying for you. Hey, no, life is good. Life is good. Don't mistake. I'm not a victim or anything like that. Life is life, right? Life is life, and we support those that we love. Even when they piss you off and are annoying, you support the people that you love. And when they're going through something, you're there for them. That's family, right? This is massively inconvenient to me. But here you go. That's family. And I encourage anybody to, I know your family can piss you off. It can be annoying. But one lesson I always tell my kids is you have friends, you have other people, you have family. Your brothers and sisters will be there for you when no one else will. When you're the worst person in the world to everybody, when everything is against you, when the world hates you, your brothers and sisters, of course, us, your parents, we will be there no matter what. If I can encourage anybody to do anything positive in their life, it's to be that for the family member that is next to you. Even the one you don't talk to because they're a weirdo. So, Cringe Lord says, honest question. Why are all the actual lawyers on Twitter saying this case has no leg to stand on? Feels like coordinated attack, but also feels like I might be in a bubble. Real talk, does Vic have a victory path? Real talk, yes, Vic absolutely has a victory path. Other real talk, this is very important. Thank you so much for reminding you. I was thinking about this on my run and something I needed to address today. Don't discount the criticisms of other lawyers. Don't do it. Don't discount them. Discount their method of criticism. Discount their bravado. Discount all of that. Discount all of that. But never discount their assertions. These are still trained attorneys. They're still presumably of higher skill level than you. They may be of higher skill level than me. Don't discount their criticisms. Certainly. I can guarantee you that Ty and Beard Harris, Bullock and Hughes take these criticisms very seriously for what they are, and they go ahead and they're constantly, you always are measuring the validity of your case, the sufficiency of your evidence. You have to do that. You have to. Doesn't mean they're right. Doesn't mean they're wrong. The right or wrongness of them doesn't matter. Any criticism from another trained attorney is valid in as much as you have to consider that they might be right and that you've overlooked something. So my encouragement to you guys is you can make fun of Greg Doucette and Akiva Cohen. I don't care. Make fun of them all you want. I think they're stupid. I think they're wrong. I think they've commented on cases that they're not sufficiently apprised of the facts on. But take their criticisms, weigh it, measure it, look for alternatives. Always challenge your own argument. I would never, ever discourage someone from doing that. So, and believe me, I take their criticisms as an opportunity to make sure I am more versed in Texas law than I was yesterday. Queen Nida says, anyone into lolly and cubs are pedos. There's no reason for a normal individual to enjoy the sexualizing of a minor. It's a sick power fantasy. Only those deserving of Prometheum fire can indulge it. So there you go. There you go. Oh, dang it. I realized what I forgot to say really early in the stream. I'm a little upset that Ty, and you have to forgive him. He's a boomer, okay? Like a real boomer, beyond me. Ty suggested something to the Kiwi Farms last night, and I was trying to walk him back from that. I don't think it was proper, personally, of Ty to ask the Kiwi Farms for some sort of assistance. You guys, of course, know why. Not your personal army. So, on behalf of Ty, let me just implore everyone to go ahead and forgive him his boomer moment. Ty is not used to dealing with the internet. Ty is used to dealing with people. Where you ask people for something when you want something. You go ahead and just say, hey, you know what? I would consider it a favor if you did this. That's a completely different thing. The internet, you don't do that, and he just doesn't know. He just doesn't know. So I would implore everybody to mulligan him on that. I've gone ahead and said, you know what? I don't think that was the best move. I tried to do it on stream, but you know how streams are, right? So just so you know, that's where we're at on that. Mick Barrel says the left claimed that pedophilia, zoophilia, etc. was a slippery slope fallacy. Do you think we're going down an actual slippery slope, or do you think the internet or other factors are making these perverts come crawling out? I think that I do think there are people trying to normalize this stuff, and I do think that's a slippery slope. And I don't think it's a fallacy at all. I think it's a reality. Yeah, just so you know. That's what I think. I don't have much else to say on that. Okay, where are we? Oh, and no, I don't know. Greg declined publicly. Greg declined my private invitation to have him on. He still has not returned a private message to me, and that's fine. No, I don't think Greg will come on. I don't know. I'd welcome him on. It would not be, like I said, it would not be another Shane. It would just be me talking to another lawyer. Here's the annoying thing. Even after all of this, I would take a discussion with Greg very seriously. Very seriously. I don't underestimate my counsel. Opposing counsel routinely underestimates me. I don't do that. Oh, that's one thing. That's another thing I forgot to talk about. Greg is trying to pretend, while giving advice to potential parties to lawsuits, that he's not opposing counsel. That's one of the really interesting things here. He's advising Jesse Pridemore, apparently advising Mars Girl. And yet, He's trying to pretend. He's trying to pretend that he's just some random commentator. I don't know if you are, Greg. Better be careful, Greg. You could get roped into this in lawsuit form if you advise him too hard. Chronoflation says another off-topic comment. But I had to pause your video and saw a journalist got 3 sponsors to drop the quartering to. Might make for a good person to invite on the show to consider possible legal action you could take. Yeah, I'm already planning on inviting the quartering on to discuss that issue. I don't know if he'll come on or not, but I'm going to invite him on to talk to him. I've been waiting to talk to Jeremy for a very long time. It would be a lot of fun. I think he seems like an interesting fella. All right. Archie Ratsworth says sipping bourbon and ginger ale in Australia. Oh wait, I read that one. Trivia aficionado says, wait, I read that one too. Finn Frog says Shane Holmberg. What is a good wine to pair with GH base dress shoes? Always go with a proper Pinot Noir. Mike says, what's this? Discovery on my birthday? Why, thank you, Nick. You're too kind. Yeah, I'll see you on your birthday, buddy. Kaki Onsai says, Greg Doucette sounds like Shane when he says that. Harbinger 345 says, you get free money for your wonderful insults. Thank you, sir. Or ma'am. James Spoon says, only person who tweets the appropriate amount is Ty. 5 words made people figuratively urinate themselves. Yeah, that's great. Hey, Pax. Glad to know you're here because the quartering talked about Vic's case. That's great. That's great. Finn Frog says, come to the Kick Vic side. We have shoes. Fantastic. Internet Tab says, T. Greg crowdfunds for cases he does pro bono. That's interesting, isn't it? Mark C says, any chance of having Steven Crowder's half Asian lawyer on the show? I'm working on it. I don't know if he'll want to because it directly involves his client, but I would love to have Bill on the show. Mike Lombardo says, lol, I've been DMing with this guy for a while and I'm pointing out several things out he just does not get. Told me he read the doc. If so, it's so obvious he hasn't. I think you're talking about Greg at that point. Cody, thanks for donation. To Jen says, who knew Tug was a young man? Mind equal blown. Well, hey there. Tug's kids are a little bit young, so I would assume that Tug is quite a bit young. Pro Jared's groomed fan says, big ups, Liquid Richard. Forever229 says, but Nick, they're super lawyers. They don't need to read anything. They know the law with just a glance, right? Yes. Yes, they do. Cape88 says, Greg speaking to Nick, are you not entertained? Kevkelius12 says, Nick, you know what to do. I love that umbrella guy. And I do. I can't wait to see him at Matsuri. Ilmario91 says, ga, please. Finn Frog says, this is for socialism is for figs. They apparently are all out of figs. ERB Beta Patch says, use this to buy orange drink or a fruit roll-up will do. Harbinger 345 says, here's $5. Not because of Vic, not for the GoFundMe, not because you're a lawyer. It's not for any of the things they say, just plain old wicked Jew powers. Lady Cat says, don't forget class. Go to Dr. Pizza's Twitter and post your anime smug face today. Dr. Pizza is the guy we just discussed. Peter Wright, I think was his name. Peter Bright. Whatever. I don't remember the names of degenerates very well. The Fallen 0830 says, dang, like take a step back and just think, how must Vic feel now after getting backstabbed? Like this man probably thought the world of Monica, Sean, Chris, etc. I hope he's going in for the kill with the lawsuit. We'll see. ERB Beta Patch says, does it count as pro bono if you're having other people pay for your clients? I don't know if it does. I don't know if it does. Bookham Dano says, language. Sorry. A little inebriated, tired, and annoyed with all of this. The captain says, rare, not R. Chronoflation says, Chase Bank canceled their payment processing. That's in regard to the Proud Boys. It may be tortious interference then. Maybe it depends on the states. Drunken Ranger says, Greg, douche, bitch, sorry, not sorry. Angry Kitten says, anyone can be a super lawyer for a $3,000 application. Of course they can. Of course they can. Elias says, hey man, found you while looking for stuff on the lawsuit. Really loving the content. Keep up the good work. Hey, thanks, buddy. I appreciate it. I'm glad you're here. Phil82245X says, Nick, you know they're going to fight Discovery. They said they wouldn't, but now I think they might. And I think this is the catalyst to do it. I think this is their excuse. No one important says, watched and loving Jello Apocalypse's Ruby video today. Went to his Patreon today to hear his behind the scenes thoughts. He called Vic disgusting. Okay. Asia Fraser says, what's the worst insult to call someone, Greg or Shane? Shane still. Shane still. Neophytus says, hey, Nick, lawsplain the Constitution sometime. I mean, I guess I could. I would rather have someone else do it. It gets a little dry. I'd love to have someone else do it on stream with me. How's that? That's what I mean. It gets a little dry at times, so it's great to have another mind to talk to about it and to explore it. No one important says, part 2, did some light ribbing and gave him a bit of my opinion on it. Suddenly blocked. No DM, no chatting about it. Booted me off his Patreon. Wow. Oh, that's the Jello Apocalypse thing. Wow, that's amazing. Professor Azriel says, more like Greg, douchebag yet. Ranstein Hernandez says, Nick, your rants may be aimed at Greg, but even I feel intimidated. I'm just here with an awkward stare. Teak Turtle says, I love you how you have to teach these guys baby's first defamation lawsuit. Talbot Link says, just did a parody of Cult 45 on Rule 45, and these clowns and YouTube won't let me send it. That's too bad. Cass Michael says, using ancestry sites, I prove Doucette is a Jew. Oh my goodness. Oh, funny. Colin Lorenzo says, Vic Lasagna is the greatest Italian VA of all time. Bad Dragonite says, in Trump voice, he's frankly the biggest raper. No one rapes harder than Greg Doucette. Fantastic rapist, traditional rapist, really, really. The type of rapist we all aspire to be. Really the type of rapist that make you look back in fondness on the strong years of raping that he brought up until now. Really tremendous. No one rapes like Greg Doucette. Greg is the best rapist. I really hope all of you are raped by Greg. Okay. Green Bullet Prod says, monetization got R to the A to the P to the E to the D. Here's 5 to compensate. Thanks, buddy. Karen D says, fire. Case H says, can you get public intoxication for ranting on YouTube? Minnesota, this is a fun law in Minnesota. Minnesota actually does not have public intoxication as a criminal charge. In fact, Minnesota is so pro public intoxication that they have a statute specifically stating that being intoxicated in public is just fine. So Minnesota loves to be public intoxication. Or loves to be publicly intoxicated. Sorry. Phoenix Lord Asserman says, here's some money for the epic rant. Well done, Nick. Thank you. Frontal Enthusiast says, I need a cigarette after that. Me too. Ranstein Hernandez says, Nick, your mic went mute for a few seconds near the start of your big rant just a few minutes ago. I was probably yelling too loud. Skeletal Mesh says, Nick, even your mic went bruh after that rant. If that doesn't warrant a super chat, I don't know what does. Cheers, man. Hey, thanks, buddy. Pony Cordero says, I've been Greg the whole time. I'm a sleeper agent programmed to release stupid opinions days before discovery to give the defendants false hope. Andrew War Snowboard says, don't you remember they're going to relish court? Yes, they love it. They would love court. Joshua Bailey says, think we all need shots after that rant. K Maxor says, first time super chat. That rant was beyond great. Keep it up. Hey, thanks, buddy. S Cybertaz says, the Buzz Lightyear looking freak didn't beg for money to buy a CPAP machine. It's a breathing device for when he visits Uranus to stupidity and beyond. Miles Tails Power Fan 9 says, I think Nick earned his Red Lantern status. I don't know what that means, but I'll take it. Sergeant Fuck Off says, get yourself some cough drops for Anime Matsuri. Good work, man. Great Loner says, Ars Technica, we're also going after Cody Wilson, especially after his arrest for statutory rape. Funny how things work out. No, it is. It's always funny. Ravelin 1 says, just when I think I hear the epic Rekieta rant to end all epic rants, you go above and beyond. I think they heard you on the space station. Oh, no. Sorry if I got a little too loud. A2P says, your rage at CPAP lawyer woke me up from a 5-hour slumber. Rando number 9 says, degenerates like these belong on a cross. Dustin Fitzfar says, the only cure for a predator is a bullet. There's no such thing as a map, only a criminal. Bring back public hangings only for these monsters. Blade Master 1942 says, after hearing this stuff, I need a drink now. Forever 229 says, be careful, Nick, with how YouTube has been. They could try to target you for this subject. Yeah, except YouTube loves pedos, don't they? They just freaking love pedos. Over and over, we have evidence that YouTube loves pedos. So I'm not too worried about it. Ezitong, oh, well, maybe they'll demonetize it because I'm talking about a pedo who they love. Ezitong says, notice this sick freak frames it as teaching children about sexuality. Right. He deserves the rope. And not the quick one. Julio Santoyo says, my sister said she wanted to be a lawyer to end gun violence and mass shooters. Well, then she shouldn't be a lawyer. Teak Turtle says, I'm a real victim. He always said he was teaching me how to please my boyfriend when I start dating. I believed him. I was 6. He was 20. Oh my God. I'm so sorry. I'm so sorry to hear that. Rocky Top Otaku says, I'm still alive. Hey, good. I'm glad you are. Gojira, thank you for the donation. Malachi Tomlinson says, have you seen King of the Monsters and what you think? God, I want to go to a movie. I don't have time. Maybe down in Houston I can go catch some matinees before Matsuri really kicks off. Jared Moore, thanks for the donation. Jay Smith says, do not shout loud, inophobe to clip the audio again. Sorry. Yeah. MMA Force says, never give an inch to an SJW. You'll have to fight 100 times harder to take it back. Well, that's because they're used to inch-long penises. Am I right? Captain Awesome says, looks like that Popat guy is taking jabs at you from behind the block shield. I don't care. I don't care what Popat thinks. Sorry, Ken. I don't care. Brian W. says, your opinion of the validity of laws, such as public intoxication, when one state says it's illegal and another state says literally doesn't care. First super chat. You know, states get to define their own laws, and I'm for states' rights in doing that. I think the federal government has overstepped their bounds on states' rights. And even on stuff I disagree with. Lil Poo Poo says, Ty getting into his first Twitter scuttle. They grow up so fast. Sob, sob. Austin Hartless says, good news. I still have a job for now. Yeah, buddy. Oh, honestly, that's the best news I have all day. Thank you. I'm so glad that you still have a job. I was really, really concerned that you were going to lose it. So congrats, man. Hold on to it. Make yourself indispensable to the company or find something better. Whichever one is better for you, but I'm so glad to hear that. Kagi Onsai says, I think I may need a vacay after that rant. Damn. And Jarl of Swart says, CPAP is Greg's euphemism for penis enlargement. SM Scorks 89 says, can you give a shout out for Micah Curtis? He's launching his comic on June 8th on Indiegogo. Hey, Micah Curtis. Go get him, buddy. If you want to talk to me on my show, if you want me to promote your comic, I love independent comic creators. I'd probably have you on. Hit me up, bud. Hit me up. Finally, Mercenary X says, I have a simple policy. This last thing, is it real? No. Then ignore it. Is it real? Yes. Put these sickos into a rocket and they get to pick deep space or the sun. Drawings are just that. Kids are real people. That says no mercy, but what God will give. No mercy, but what God will give, I think is the last word there. And finally, Meshikari Roos says, so I'm a bit dumb, lol. The depo for Vic is on Monday. We don't actually know when the deposition for Vic is yet. If so, won't both be ordered to have depots before Casey can try the TCPA as a result of the hearing? Casey promised not to file the TCPA until after depositions in court on the record. If he goes against that, he's going to have to tell a judge why. Monday is the deadline for Ty's document production requests to Casey and company, to Monica and Ron, that were filed with the initial lawsuit. So they have until Monday to make a motion as to why they don't present the documents, or they have to present the documents. Raccoona says, I don't want anime lolly to be normalized. I hate that thought. I just want the fictional stuff left alone. I hate that we get called peds when we don't want anything to do with that disgusting real world crap. Is that so wrong? No, it's not. No, it's not. In some ways I agree. I'm not a fan of lolly and in any way. And I think if you are a fan of lolly, you should guard yourself. Guard yourself. If you're a fan of lolly, guard yourself and make sure that you're in the right place. However, art is art, and I don't want art censored by the government. I want the market to take care of it. So that's that. All right, guys. All right, guys. I've got to end the show. I love you. I love you. And I miss you. Just kidding. Tomorrow I will be at an event. Tomorrow I will be at a charity event. I'm the worst person on earth. I plan to go donate thousands of dollars to a charity. Sunday, please tune in. I will announce the show as soon as I figure it out. I'm really hoping I get to read Ty Beard the LOL suit soon, or something equally comparable. Sunday should be a fun stream. No pedos, no idiotic lawyers on Twitter. Just fun. I love having fun on this. Yesterday was so draining. You could see it, right? You could see how tired I was by the end of that stream. Today has been great. It's been energizing. Thank you guys for engaging with me and watching this content. Let me start this outro. Oh no. Hold on. Here we go. Let me switch it to the proper output here. Here we go. There's the outro for you. Let me turn it down a bit while I wrap this up. The outro is playing. That means the show is ending. Thank you so much for joining me. I will see you on Sunday night. Sunday night, same time, 11 p.m. Central. Unless you see otherwise on Twitter. If you're not following me on Twitter and you're watching this, oh my God, why are you not following me on Twitter? Please also, if you're watching, smash the ever-loving hell out of the like button. I'm so bad at asking for likes and subscriptions, but please do so. It helps so much. Don't blame me for being a bad salesman. Blame you for not taking the initiative. No, I'm just kidding, of course. Please go ahead and like, subscribe, and click the notification bell. Make sure you're here for the streams. Thank you all for watching. I'm gonna peace out tonight. There will not be a Twitch stream tonight. I am far too intoxicated to manage a Twitch stream. But Sunday night, I plan on doing one. I've got Chaos Bane to play. I've got It Lurks Below by Diablo creator David Brevik, which is like a Terraria action RPG. Look, it's fun. I played it a little bit, a couple hours the other day, like an hour the other day. It's actually kind of fun and interesting. So I will do a video game stream probably on Sunday, Monday, maybe even Tuesday. Then I'm going to Anime Matsuri. Anyway, thank you all for watching. I'm going to stop rambling now. Have a good night. Peace.
Shores of Nairn to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the law what we have.